Hey, what matter? Where the reason is not listed. Hey, have a copy to the other side. I don't allow this type of mentioning now. Today, tomorrow, when do you want? Mr. D. Chakravarti, the learned counsel appearing on behalf of the petitioner submits that the petitioner have already received the amount for which the petition has been filed, and as such submits that the petitioner would not like to further pursue the initial petition. In that regard, he has placed an instruction, placed an order of the communication issued by the Chief Engineer, Irrigation Department, dated 33/2026, which is kept on record and marked with the letter X. Taking into account the above, the petition therefore stands closed. Item number? Where's the so-called notice? Then the notice making it returnable on 25th of May, 2026. Ms. So and so accepts notice and accept notice on behalf of the respondent numbers 1 to 4. Those extra copies of the petition be furnished to her during the course of the day. The case of the petitioner herein is that the petitioner is the owner and proprietor of MS Joy Medical, situated at Jyotikosi, Sokosi, Kamrup Metro, and also holds a drug license bearing number D/OL/KMP/16588-16589 and has been running the said pharmacy since the year 2019. On 7/1/2026, the Inspector of Drugs, Kamrup Metro, accompanied by a team of police personnel from Budalbakra Police Station, visited the petitioner's pharmacy and alleged the petitioner had violated Rule 64 of the Drugs and Cosmetic Rules 1945 and the provisions of Schedule N of the Drugs and Cosmetics Act 1940. On the same day, the petitioner was arrested by the police on the basis of an FIR lodged by MS Sun Pharma Laboratories Limited. However, subsequently, the petitioner has been released on bail by an order dated 9/2/2026. It is a further case of the petitioner that on a so-called notice was issued on 7/1/2026, directing the petitioner to submit a reply within 2 days. However, the petitioner was incarcerated till 9/2/2026, and as such, the petitioner could not file any reply. It is the further case of the petitioner that the said notice dated 7/1/2026 was received by the petitioner on 27/2/2026. In the meantime, on 19/1/2026, when the petitioner was incarcerated, the petitioner's license was suspended by an order issued by the drug controller in charge and licensing authority, Drug Control Organization, Assam. The petitioner thereupon filed an appeal on 17/3/2026, which was duly received, which was duly sent by way of post and was delivered on 18/3/2026. However, till date, the said license have not, the said appeal has not been considered, and it is under such circumstances the petition has been filed. The learned counsel appearing on behalf of the petitioner submits that the said impugned order dated 19/1/2026 was passed at a time when the petitioner was incarcerated, inasmuch as the petitioner was arrested on 7/1/2026 and was released on bail only on 9/2/2026. And therefore submits that on the face of it, the impugned order dated 19/1/2026 is without providing a petitioner a reasonable opportunity to submit a show cause notice. He therefore submits that this is the case where there is a violation to the principles of natural justice. The learned counsel appearing on behalf of the respondents are directed to bring on record their stand by filing the affidavits on or before 25/2026, 22. In the meantime, the respondent, more particularly the Secretary to the Government of Assam Health and more particularly the respondent number 1, the respondent, who is the appellate authority? Respondent number 1. In the meantime, the respondent number 1 shall duly take note of the appeal which have been filed by the petitioner on 17/3/2026 and take a decision and place the same before this court on the next date. A copy of the instance certified for the petitioner is further direct that within 5 days from today to serve a certified copy of the instant order upon the respondent number 1, along with a copy of the along with a copy of the memo of appeal filed on 17/3/2026 for due action by hand. This court further observes and directs that the pendency of the incident with petition shall not be a bar on the part of the respondent number one to take a decision in respect to the appeal filed by the petitioner, and more particularly taking note of the contents of the present order.
And till then, I may be allowed to run the promotion.
How is it possible? You also understand. I gave you everything. I in fact almost allowed the
Yes. Much already.
The case is as simple, my lord. My call deposit, my lord, that has not been returned to me.
what?
My call deposit of 1,20,000, my lord, which I have deposited during the course of the settlement, my lord, I did not get the settlement. There was a writ petition pending also, my lord, that was also complete, disposed of, my lord. Thereafter, my lord, I have approached to the authority, my lord, authority doing the ball from one corner to another, my lord. Lordship, kindly have a look at page 35.
What is this order on 7/1/2025?
My lord,
Lordship, the co-district commissioner has requested the commissioner secretary, fishery department, to return back the documents so that the needful can be done. So that whatever is required to be done can be done, Lordship. They have taken up the issue. They have duly
They have
communicated to
taken
the
up the issue on 7/1/2025. Is it walking or rolling? Is this communication walking to the fishery department from where? Kodia. Oh, it's far off. Mr. Borduya, it's so far off. It's rolling. So from Kodia to the fishery department at Dispur, it's taking more than a year.
Lordship, at this point in time, I request to issue notice, Lordship. Fishery department will also come to the picture.
that to take instruction, my lord, is simple matter, my lord, to return my,
Mr. J.I., we and with me, this court does not disturb the respondents without issuance of a notice. Other courts are good, they put it, but I will not do it. Issue notice making it returnable on 29th of May 2026. Mr. So-and-so accepts notice on behalf of all the respondents.
No, Lordship. I will be appearing for respondent number 4 and 5.
What? Who appears for the fisheries?
Fishery department, Mr. P. Sharma. Normally he
Fisherman
appears.
is not there. Fisherman, Mr. Dina, who accepts notice. Fishery department. He's the senior government advocate. He can accept notice for everybody. Mr. Dina accepts notice on behalf of the respondent numbers 1 and 2. Mr. Ed Gotoy accepts notice on behalf of the respondent number 3. Mr. So-and-so accepts notice on behalf of the respondent number 4, 5, and 6. Extra copies of the writ petition be furnished by tomorrow. It is the case of the petitioner that the petitioner participated in pursuance to a notice inviting tender, in pursuance to a sale notice dated 4th of October 2019 for sale of the Brahmaputra Part 1 and Dibang Valley Fishery under Khotia subdivision in the district of Tinsukia, Assam. The petitioner at the time of submission, submitting the bid also submitted a call deposit amounting to rupees 1,20,150. The fishery was not settled with the petitioner, and as such, the petitioner, in terms with the sale notice dated 4/10/2019, was to be returned the said call deposit. The said call deposit having not been returned to the petitioner have run from pillar to post. It is also seen that on 7/1/2025, the Fourth District Commissioner Hodia has also written to the Fishery Department of the Government of Assam for the purpose of release of the call deposit. However, till date, the call deposit of the petitioner amounting to rupees 120,150 have not been returned, and it is under such circumstances the petitioner is compelled to approach this court. This court observes, this court directs the respondents, more particularly the respondent number 1 and 2, to bring on record its affidavit as to why the call deposit dated, the call deposit of the petitioner have not been returned in spite of the communication issued by the Court District Commissioner Kodia on 7/1/2025. Full. It is further observed that till the next date, it shall not be a bar on the part of the respondent authorities. Have not been returned. Full stop. It is further observed the respondent numbers 1 and 2 shall also apprise this court as to why interest should not be imposed upon the respondent authorities, concerned respondent authorities, for not returning the call deposit to the petitioner. In the meantime, it shall not be a bar on the part of the respondent authorities to return the call deposit to the petitioner. They will return. Mr. S. Hawk, seeing the name, I see where is the standing counsel for Mr. Gauhati. Wait, what is this?
My lord, here, my lord. And NIT was initially, my lord.
Site visit?
Site visit was, that part was done, my lord. What
Okay.
happened, my lord? The petitioner was not allowed to submit hard copy of the technical deed. Hard copy of the deed, my lord, he was not allowed to submit, my lord.
Why?
Because, my lord, he was obstructed on the way by one Nikul Kolita and on Hiran by Das, my lord. So, my lord, he has lost a complaint before the, my lord, professional secretary, my lord, that so that he may be allowed to submit his hard copy of the deed before the chief engineer, my lord. Page 27, my lord.
When was the date on which you were required to submit?
20th of December.
28th of?
December.
And why you are approaching this court today?
My lord, this, my lord, the notice to proceed to work was issued on only on 10/3/2026. And it was uploaded.
Your
by
cause of action arose on 20/12/2025.
Yes, sir.
So when your cause of action arose on 20/12/2025, why after 4 months you are approaching this court?
Because, my lord, you had submitted the
Withdraw, dismiss.
No, my lord, kindly
Withdraw,
come to,
dismiss.
My lord,
Either of it.
just for a moment, my
No,
lord.
sorry.
Come to page 27, my lord.
No, this court is not going to touch it. You should have immediately approached this court. And this particular person on 20/12/2025 must have filed at that point of time 4 or 5 petitions.
No, my lord. Here, this was, my lord, only,
Huh?
my lord, this
Because
was,
at that point of time, I was taking up the bench 4, and I could see Mr. Vyarpasa busy with a lot of site visit certificate matters. Why on earth you didn't move
My
this
lord,
petition?
these documents, my lord, these documents was uploaded only on 31st of March 2026. my
I'm
lord.
not concerned with the fact.
Yes, my
but you see,
And-
no, kindly see, kindly come to page 27.
My lord.
Prayer for accepting the offline bid
Yes, my lord.
with so and so, so and so, so and so, so and so. And subsequently, and you are approaching, being agreed, I have filed the requisition bearing number so and so, and the same has already been intimated to so and so. That, sir, after submitting my bid through online media without the site visit certificate as so and so, while I went to the office of the so and so for submitting the bid to contractors named Nikul Kolita and so, along with some other unknown person, stopped me in front of the office of so and it snatched my mobile phone and the bid documents against the 2 packages and had threatened me. So this, and you have filed the FIR on 2012.
Yes,
Why should this court now entertain after 4 months?
my lord, this petition, my lord, that has not yet taken into consideration, my lord.
That's a different thing, but that is not the case.
My lord, yes, my lord.
No,
Because
what
Can-
has happened in the FIR?
kindly come to my lord prayer portion.
No,
my lord.
sorry.
Kindly
The
come to
FIR,
prayer
what has
portion,
happened? What has happened to the FIR?
The police have not taken any action, my lord.
So you
It
come
was
up
lost
for
through
that.
online mode, my lord.
No, if you want to come for that. Come for that, but not for that. Sorry,
My lord,
after notice of proceed to work has been issued, then why
my
not?
lord. There, my lord,
Yeah,
if
no,
your
no,
lordship,
entertain
my lord,
this type of
kindly, my lord,
Sorry.
if your lordship has a look on the page number 31, my lord. Here, my lord, also your lordship find this, what they have done, my lord. Here, your lordship will find the date, my lord. On the top, my lord, date is 10/3/2020, my lord.
So,
And their reference, kindly come to reference, my lord. Reference, whatever, my lord, LOA, so and so dated 13/3/2020.
Huh?
And come to the reference, my lord. Reference, my lord. This office LOA number so and so dated 13/3/2025. LOA was issued, my lord, on 13/3/2026, my lord. And notice to proceed with work was issued 10/3, my lord.
so,
My lord, LOA was 13, my lord. Our notice to proceed to work with it can be issued on 10/3, my lord. Prior, 3 days prior, my lord.
so
Yes, but
What
this is
you-
also fishy, my
you
lord.
are an ineligible contractor. As per the terms and conditions, you have to submit the hard copy. You have not submitted the hard copy.
My
And
lord,
if
I
you are,
was, my
if you
lord,
are ineligible contractor, you cannot challenge.
my lord. Here, my lord, these documents are uploaded only on 31st night, 31st of March,
I
my
can
lord.
do one thing. I can issue a notice. What is the period of completion? 18 months?
Only have a look, my lord. They have
Sorry.
uploaded the documents of the bid on 31st March.
No, no, you are not submitting the hard copy is the basis.
My lord, they were not allowed to submit, my lord.
Understood. Then
Well,
why didn't you approach the court immediately?
My lord, because my lord, it was under petition for the, it was under consideration. Only while, my lord, they have uploaded on 31st March of this year, my lord. Here only, thereafter, my lord, here came to court, my lord. 31st March, my lord.
18 months lodged. Completion.
Who are you?
I'm for the petition.
And what PTC has to do? You know, the main, the issue that is.
Earlier it was issued by the chief engineer PWD road, my lord. That was cancelled, and in continuation of the earlier, my lord, absolutely the external chief engineer of the Kopraza, my lord, they are issued by PWD.
Sorry, like,
I am not on that part, my lord. But the hard copy, my lord, I was obstructed, it is genuine case, my lord.
so what?
My lord, and you lost.
If you have
They have-
such
they have
a, such a genuine case, my question is, why didn't you approach this court then?
My lord, they have uploaded only on 31st March, my lord. Uploaded the documents online, my lord, only 31st March, my lord.
So what?
And after 31st March, I came to know, my lord, because the petitioner was in the impression that he will be allowed to submit hard copy, my
You
lord.
also know, your petitioner is knows very well.
No,
Yes,
he knows
yes.
very well,
He has some problems with the PWD.
because nothing was.
No, no, Mr. You also know that the petitioner knows very well that without an order of the court, the PWD authority does not favor him.
My lord,
So therefore, why didn't you
my lord,
approach?
here, my lord, kindly come, my lord. Petitioner had earlier approached the court, my lord, case 24, my lord.
That is for side visit.
Yes, my lord.
After that, why didn't you approach this?
My lord, because while this insurance pending, my lord,
You are in ineligible.
my lord,
No, I'll help you.
my lord, because, my lord, sir, kindly see, my lord. Once he was obstructed, my lord, from submitting his bid, my lord. If the detention was
Mr.
submitted,
Bhuya, when the work is completed,
what I completed, my lord, just issued, my lord, work order only issued
when it is to be completed?
within a,
Within 18 months. So we have it issue notice returnable on the year 2028.
my lord,
You are coming before this court unnecessarily for at a later point of time, this court is going to dismiss your petition.
my lord,
There's no way, Mr.
My
Counsel,
lord,
there is
I-
no way
Mr.
this court can allow you. So therefore, your petition will be dismissed. Why we put another petition out here in the file, in the document?
my lord, this work order only issued on 10/3, my lord.
So what?
10
This cannot be done into because of the fact that you did not approach, you should have approached there. Why haven't you, have you made the police a party? Why there is no prayer that no action is being taken in respect to the police case? Why there is no prayer to that effect?
Yes,
Where is the case number which have been initiated? Where is the police station case number? You have sent it by post.
yes, right.
Why?
So online mode,
To the,
online mode.
to the,
The officer himself ko present, yes.
the online mode, you must have got it registered. And
Not
if
yet
it is not
registered, madam.
registered, why haven't you taken any action? These are things which are required. Without these, you don't have a case. You have to make the officer in charge a party, saying that no case has been made out. And in spite of that, they have not taken any action.
Right.
Then you may develop your case somewhere.
Yes, yes.
Now, as of now, what is your case out here? Then look here, on 2012, when we went out there, this particular person did not allow me to deposit it.
Right.
For which I have filed an FIR also, and I request to kindly allow deposit the online. That is there. Then immediately the period was over. You also know, I also know, he also know that you cannot be allowed beyond a particular period of time. Either it may lead to a cancellation because of you being obstructed from doing so. For that, you have to initiate the process for that FIR. You have not done that. Without that process being initiated, you cannot go there. Then you may have a charge sheet, you may develop your case in that manner. This is not the manner in which you do
My
it.
lord, yes, yes. Then, my lord, I will include, my lord, the result.
But implicitly, without the pleadings. You have to initiate, you have to ask, you have to seek for relief against that police officer that they have not registered. Develop your case in that manner. It is not for just for
Yes,
to
yes,
give you advice.
I got, yes.
Huh?
I file a press.
Ah. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file, withdraw the instant petition with the liberty to refile, taking into account that certain reliefs which have been sought for in the, that certain reliefs the petitioner have failed to seek, which were necessary for a proper and effective education of the present issues. He therefore, Mr. S. Hoff therefore submits that he may be permitted to withdraw the petition with the liberty to reply, taking into account the above, the petition stands closed on withdrawal. Petitioner granted liberty to approach this court by removing those formal defects.
Fine, I take your.
You come up and file a petition to get my advice. It is something like that.
Okay.
Yes, Mr. Doctor, what is your case?
The petitioner is seeking to open a nursing college. And for
Huh?
that nursing college.
Ah.
For that purpose, they applied for an LOI. That's the first step. And now, the last communication was that I should give some documents, particulars, at page 49, annexure 5. That was complied with, annexure 6, page 50. I had given the particulars which were sought for. And that was received on 10/11/2025. Thereafter, the matter is pending for them, without any further progress. Now, the academic session, of course, this year starts, from the last date of admission is 30th of September. It's the entrance test, etc. It starts from 1st August, the academic session. Page 20, page 20.
Now, what do you want?
Since the matter is pending before them,
For?
They have not considered thereafter. After I have given this,
You have applied for what?
nursing college, permission for LOI for nursing college. That's the first stage. Thereafter, they've given me an LOP. If I fulfill, then the college will
What is
start.
this LOP?
LOP is letter of permission.
You are asking for letter of intent.
The first part.
They have not given.
They have not.
Where's your representation?
Well, representation is page 37, 47. Is the representation. It was followed up.
Yeah.
Page 47.
Where for NOC to start?
Thereafter, my lord.
No, thereafter the things have moved.
Well, but then,
Now thereafter, when there is the stop,
Well,
where they have not enacted.
yes, no.
Then you are
8/11
asking a court for issuance of a mandamus without seeking demanding justice.
Well, since thereafter this matter has been stalled there, my lord.
It got stalled thereafter.
That's the reason, my lord, since my lord, he had
Then why
already applied.
you are coming before this court?
There perhaps ought to be another representation, that's true, my lord.
No, you should have given a
Well, that's true, ma'am.
When you're there, then you can come. Now, this has happened till 8/11, you have submitted.
Yes, ma'am.
Then thereafter, what has happened?
Nothing, my lord. Nothing has happened. It's not there. They have not done, my lord, neither informed, my lord, any rejection, my lord. Or, my lord,
What do you want?
Madam, in that case, I would have to obtain instruction.
So you want a notice?
Notice or instruction?
No, notice has to be
Yes,
given.
yes, madam.
That means you want this court should not dispute. Seems that the health and family welfare people are not filing petition. There is no materials or there are no cases for health and family welfare now. We are asking for a notice. Issue notice making it returnable on 5th of June 2026. Mr. D.P. Bora accepts notice on behalf of the respondent numbers 1, 2, and 3.
Madam, I am for 1 and 2. Thank you.
1 and 2. You for 3. The MC Bhuya appears for respondent number 3. Extra copies of the writ petition will serve upon them by tomorrow. The petitioner herein have set up an infrastructure for establishment of a BSc nursing college in the district of Cachar, at Silchar in the district of Cachar. For the purpose of running the state, for the purpose of going ahead with the establishment of the said nursing college, the petitioner is required to obtain a letter of intent from the respondent numbers 1 and 2. The petitioner, it is that Mr. M. Dotto, the learned senior counsel appearing on behalf of the petitioner, submitted that petitioner had fulfilled all the formalities as have been sought for by the respondent number 2. However, since 8/11/2025, when the petitioner had fulfilled all the required documents, the respondent authorities have not taken any steps, and resultantly, the petitioner would be missing out the coming academic session in as much as notifications have been issued, an educational notice has been issued by the respondent number 3, stating inter alia that the session would start sometime in the month of September, huh?
Well, August 2026.
August 2026.
Page 50.
The respondents herein are directed to bring on record their stand as to why the petitioner have not been issued the letter of intent. It is observed that pending next date, it shall not be a bar on the part of the respondent authorities to issue the letter of intent if the petitioner is entitled to on the basis of the material, on the basis of the documents, documents and other materials submitted by the petitioner.
Yes, sir. Today morning, I made a notification for an affidavit, my lord. The affidavit is within 5-10 minutes that affidavit will come.
You are supposed to file the reply
Yes.
of 23.
Absolutely, I understand, my lord.
So we won't consider the.
My lord, otherwise also I have not filed a very lengthy or detailed. I can make my oral submissions on the affidavit.
So you give up on that,
No, I'm not giving up, my lord. It will be, by the time we finish up, my lord, probably it will come. My lord, but the issue is this, my lord. 2024, my lord, I was declared as a
Mr. Biswas, I understand the fact that you have been all along held to be L1 or whatever. This court has passed a direction to the effect that let them take a fall now up, upon upholding, upon holding, upon coming to a satisfaction
Logical.
that the reason on which the retender process was initiated was wrong. The school came to a fact. Thereupon, the school directed them to again look into it as per the terms and conditions. Now, in pursuance to that, they have come up and taken certain decisions. But on account of the order passed by this court, they have sought for although it says be a review, they have sought for a clarification as to whether they can go ahead and hold that these are the essential requirements which are necessary, which were not taken into consideration in the earlier technical bit. And as such, without that, it will become very difficult. So they want to go ahead and therefore say that none of the bidders have submitted anything. So would it be in violation to the order passed by this court? This is the scope of the clarification. Although they have violated.
My lord, I have absolutely understood, my lord, what had fallen from your lord. My only submission is this, my lord. My lord, they initially, when they have rejected, there was 1 year, the parties were before the court. Never did they ever come up with this plea. Number one. Number two.
No,
My lord,
Mr. Pandit. Therefore, I said in my initial order, it is more of a clarification. If they go ahead, if they take a decision, they have mentioned it out, these are the things, they go ahead. And my question is whether the directions which is being passed by this court here, more particularly, number D, page 56, are directed to bring the tender process initiated by notice inviting tender to its logical conclusion as per the terms and conditions, terms of notice inviting tender dated 13th. So with this thing which is being done, if they do it, would that stop them from taking a decision on the technical aspect or not? It's a question which is open. And tomorrow, if they take it, you can very well challenge that. My question is, therefore, I'm saying it is more not a review, it's a lack of clarification. Would it be in violation? If it is so, if this decision is taken to the effect, it's a clarification that it shall not be a bar. Why should I say that? It shall not be a bar or no. I categorically mentioned this. So therefore, they say that they have taken as per the terms and conditions, that will let them do it. You are at liberty to challenge. And then we will consider as to whether this is wrong or right. My question is this.
I got, my lord, yes, my lord, when this evaluation was done, my lord, there was a column in that is what in my additional affidavit, there was a column which says challenge stroke representation. Now there on the left hand side, there was the list of bidders. Then remarks, qualified, unqualified, if rejected, why rejected, A missing, B missing. Now, if this plea, now my lord, I understood this, that they want to reevaluate, fine. If there is some deficiency, fine, reject me, okay. But it is their tender which had given me an option that if it was rejected.
I again am telling you. This is a question which will be done when you are on the other side, when you file the root petition. As of now, why should I look into that?
Can it be like this, my lord? Because that challenge opportunity now I have lost.
No. As of now, if they take a decision, if they go ahead with that technical evaluation, if they go ahead with that, then in that regard, if you want to challenge that, you can very well challenge it. And that is always a negative to do so. And then you make those arguments. That this was not a consideration at that point of time. They are going ahead. Now, my only question out here is as to whether paragraph 58D puts an embargo upon him not to go ahead with the technical evaluation. It's the only thing I'm looking at.
But they are doing the technical evaluation.
Do it. Because you see, if the question is, Mr. Nath, if you go ahead, the question is as to whether there is a willful and deliberate violation of the court's order. That is the reason why you are going ahead. You are asking for this clarification. Yes. Now, whether it will be there, that will be looked into at that point of time. The respondents are directed to bring the tender process initiated by the notice inviting tender dated with logical conclusion as per the terms and conditions. Okay. Meaning thereby I have given you the liberty. Now, if you want to do whether you can go after evaluating the financial bid to a technical bid is a question which we will decide if Mr. Biswas again approaches the court. But not now. In fact, we have faced with a penalty because in that earlier proceeding, the petitioner was recognized as the L1 bidder, it is a technically valid L1. Now, after going through the records, the committee found that two of the certificates, in fact, the petitioner as well as the other technical they have not. So that is not you can give me that credence to the effect that I remember those things. That's it. So that is why they were two documents which have not been submitted. One was this refrigerator. Yes. And the other.
Stabilizer.
So this was a perfect of tender document. Yes. And some Krishna only did not submit those two. Whereas others, there were many other deficiencies.
Which we have in our possession. Had that opportunity been given to us during that initial point of time, we would have submitted. That is why, my lord, because there was a clause that challenged representation. But if there is some deficiency, you immediately, now 2 years down the line.
As of now, I am not adjudicating the technical bit.
Your lordship is clarifying that there is no embargo in
that liberty. If they want to take whatever, it has to be within the contour. Here, I have asked you to go ahead. Under such circumstances, that is your liberty to take a call.
my lord,
Now, therefore, you see, for being a contempt, there has to be a willful and deliberate. The words which is mentioned at 56B does not stop you to do whatever you feel like as per it. Now, whether that is right or not will be looking to in a repetition when Mr. M. was I'm always here sitting out here in bench for some time. That limited clarification will go on. That is what
my liberty may be restored.
So although I would you have made all these things can be urged at a subsequent time if you want to challenge them. In opportunity and all these things, all these points which you have put in your affidavit shall be open for you to urge at a subsequent stage.
Because they could have,
you can very well write a letter to them also now. That look, yeah, I have these particular documents. So we have come to learn from this affidavit and more particularly the technical evaluation that this may give you another course for filing the. So add on to the applicably, those documents are not included in the document. Understood, but so he says out here, he has a contention to the effect. And look here, these are questions which are there, they should have asked. And there could have been a challenge, and I could have the opportunity to do so, yes, which opportunity was not granted. And now, at a later stage, after finding everything to do all these things, they are now again going for the same idea. This is what his submission is. So let it be there. You are at liberty also to submit a representation.
Absolutely, my lord. But just one where that opportunity where I missed that opportunity. Just my lord, only page number running page 90. Only that thing. That is vertical, not the horizon. Yeah, horizontal, sorry. My lord will see this is the technical evaluation at the initial stage. Mine is number 7, Mahalakshmi. Status qualified. Now, my lord will see the right hand side column, challenge representation. Now, had this after 2 years, which they are saying, if they would have, if I would have come to know at the threshold on the day when this was prepared, I could have availed this opportunity, challenge and representation. Now, this has.
This is a point which you can urge.
Absolutely.
As of now, they have only taken a decision but not brought into effect in view of the order passed by this.
That decision may be, whatever decision they take, that may be communicated to me within a given period.
You have it. It is already enclosed to the review petition.
That subsequently, because of the contract petition, we have withdrawn that.
You have not given effect,
Yes, yes.
but that decision is already there here. Kindly see that decision here.
That has been cancelled.
Kindly see technical bid evaluation at page 80.
Yes.
That decision is already there.
We have-
Now taking care of this, as well as the speaking order which was passed on 12th of December 2025. All these things you.
Speaking order was withdrawn by them, my lord. Speaking order was,
That's true. They have withdrawn the speaking order, but you have this technical evaluation.
It's
Now you have come to know, na, page, annexure D, page 80. This is what they're supposed to do. So you file a representation that I have these documents which were valid at that very point of time. Bring the Assam Procurement Act. I need not come further advice. Today, this is the third advice which is happening.
advisory jurisdiction.
I still remember when I was taking up this APSC matter, so one of the things which I was telling Mr. Kohli was appearing on the other side. Then Mr. H. Chowdhury who was appearing, he said, my lord, no advisory due. So he was there. No.
I
Now, heard Mr. D. Nath, the learned counsel appearing on behalf of the state petitioner, review petitioner. Mr. M. Biswas, who appears on behalf of the writ petitioner in WPC number 3832 of the 2024. It is relevant to take note of that though the instant application has been filed as a review petition. But in fact, the said application is not a review petition, but an application as a matter of abundant caution, seeking clarification from this court as to whether the respondents hearing, whether the applicants hearing, while carrying out the directions so passed by this court at paragraph number 58, bracket D, of the judgment and order dated 4/2026 in WPC number 3832 of 2024 can go ahead by carrying out certain technical evaluation which would be necessary for the purpose of the procurement of the materials for which the tender was issued. Paragraph number 58 of the judgment and order dated 4/2026 being relevant, it's reproduced hereinunder. From a perusal of the above paragraph, above quoted directions so passed by this court in the judgment and order dated 4/2026, it will be seen that this court made it had this court held that the actions on the part of the respondent authorities to cancel the tender notice on the grounds which led to the minutes of the meeting dated 25/7/2024 to be arbitrary, unreasonable, irrational, and also suffering from malice in law. Under such circumstances, the minutes of the meeting dated 25/7/2024 was interfered with and set aside and quashed. This court further observed and directed that the respondent authorities should bring the tender process initiated by the notice inviting tender dated 13/2/2024 to its logical conclusion as per the terms of the notice inviting tender dated 13/2/2024. There is no mention in the said order as to how the evaluation is to be carried out by the respondent authorities, oblique the review the applicants herein. What is being mentioned is that the said notice inviting tender dated 13/2/2024 is required to be brought to a logical conclusion as per the terms and conditions of the notice inviting tender dated 13/2/2024. In this regard, this court finds it relevant to take note of the submission of Mr. M. Viswas, the learned counsel who appears on behalf of the petitioner, who submits that pursuant to the judgment and order passed by this court on 4/2/2026, a technical evaluation was carried out. Afresh, the respondents have again carried out another technical evaluation of the bids so submitted. And in respect to certain documents, in the same meeting which was held on 28th of March 2025, 25, no? 25. The bids, certain documents where the tender committee sought to insist upon certain documents which, though the petitioner possesses, but at the time when the tender was submitted, as the petitioner was shown to be qualified and there was no representation or objection put to it, the petitioner had no occasion to submit those documents. He therefore submits that the instant that the move which is being made by the applicant of the respondent authorities is nothing but to circumvent the judgment and order passed by this court dated 4/2/2026 in WPC number so and so. In that regard, the learned counsel have also referred to the affidavit in opposition filed by the petitioner in the instant proceedings, and more particularly referred to Annexure A. This court have given an anxious consideration to the respective submission as well as the present application. As already stated here in above, this court, while passing the impugn judgment and order dated 24/2026, and more particularly at paragraph number 58D, did not mention as to how the respondent authorities were required to bring the notice inviting tender dated 13/2024 to its logical conclusion. It only stated, this court only stated that the same should be done as per the terms of the notice inviting tender dated 13/2024. Under such circumstances, if the respondent authorities takes a decision which is contrary to the terms and conditions of the notice inviting tender dated 13/2/2024, it shall be always open to the petitioner, writ petitioner in WPC number so and so, to assail the same, if so agreed. This court also observes that the grounds and reasons, the grounds urged in the affidavit in opposition filed with the writ petitioner in the instant proceeding shall always this court further observes. Accordingly, the instant petition, instant application stands disposed. Next. The grounds urged in the affidavit in opposition by the writ petitioner in so and so. Before parting with the record, this court observes that the instant order shall not affect the writ petitioner in WPC number so and so to urge the grounds, the contentions and the grounds mentioned in the affidavit in opposition in future proceedings, if so necessary.
Liberty for us to go ahead with them.
I've said that, no? I said I never said as to how it is to be done. I said you have to do as per the terms and conditions. So as per the terms, I feel that the price bid can be after opening of the price bid. Then you can open the technical bid to it. That will be a challenge which you.
We have.
I cannot allow you that. I cannot allow you that. My question is this: if you want to do it, you go ahead. That is your lookout. That it won't be a contempt. But the moment I say that, I therefore make it very clear that this court never said as to how it is to be done. I only said as per the terms and conditions.
Certificates are not
That is liberty.
that liberty. As per terms and conditions, those are required. Then
Why should I say that? The moment I say that, he loses his right. He loses. He can very well challenge it. I made it very clear to the effect that
They need a mandamus rejecting my bid. That is what they need.
Mr. Nath, this is the order you are going.
I'm between.
but I cannot say in the contempt petition. You cannot say in the contempt.
Oh, contempt petition stands closed in view of the order passed so and so contempt petitions. I stands closed.
I'm between.
Mr. Nath, with this order, you can go ahead. There's no quarrel with that.
Hello.
What is this?
Affidavit is already ready.
Huh?
Affidavit in reply already is ready. It's not signed the affidavit.
You are filing an affidavit in reply. Mr. So and so, the learned counsel appearing on behalf. What is this case?
Regarding non-payment of contractual.
Where is the order?
Main order is not annexed in the petition.
What is the order? Which order? What is the order which you have filed for the purpose of non-payment?
It is not annexed, but the order said that we should make payments.
What?
Yeah, to the petition.
Without the order, how can there be a contempt petition? Non-compliance with the order dated 19/6/2023. Where is that order?
That order is not annexed by them.
How a notice could have been issued in this matter? What? Operative part is being mentioned here. How do you know? The order there is mentioned somewhere. Yeah, it's there 1960. Now, why you are saying that? Mr. Counsel? They're not prepared properly, and it's a G page 27. In view of that, on consideration of the matter in its entirety, this petition is hereby allowed with the direction to the respondent number 3 to pay the petitioner a sum of rupees so and so for the material supplied to the department pursuant to the work orders above noted. With the direction.
Yes.
Now, what has happened? Who has filed the affidavit?
We have filed it on behalf of chief engineer.
What do you say?
My lord, may see paragraph 6, my lord, these anomalies have been observed in the bill.
Alan copy was not signed by so and so. There was no report of utilization of material by the site of chief. So in view of this, now therefore there is no admission. So you are therefore to go before the Supreme Court. Civil court. Huh?
Council will have to next step.
The counsel appearing on behalf of the petitioner is not ready when a matter is being, when inquired into. Accordingly, this matter on 10th of August 2026. In the meantime, liberty given to the petitioner to file reply.
Outlet.
I file.
No.
Okay, hindi mo ata kita akin ko. Dismiss po sumo. Not filing. Not. Many cases are dismissed from there. That will be what has happened. He has fought for various times. If you are happy that there is a certain formal defect, no file. He has not filed any. Now it is required to bring on record whom?
But
Huh? You have to bring on record whom? Ministry of Jal Shakti असेल हं? आणि कोणती ऑर्डर हे रिपेअरिंग साईट डिस्मिस करू क्लोज करू. Madam, tell me which order I have passed on that day, na? Just give me the number to her. I think we got, I think number Tuesday, Monday, or I'll give it to you. Monday. I remember 8. It would be similar, huh?
Yes, yes.
Contempt case 198 of 2022. There were two cases which I have proved. One is this one and the other is, yes. Item number 5. If 5 or 8 or 8
Yes, yes.
ago, that was, I think 5 was for the purpose of BC.
Yes, 5 was for the purpose of
BC and 8 was for the Jal Shakti.
Yes.
8 or two orders.
Outlet.
Yes, next one, item number 9. 9
Service upon
neither AP card nor answered notice has been received from respondent number 1, 2, and 3. What is this matter about?
one of the officers order.
And that it is relevant.
It's like
in
8
view of the
years
condition in the learning
What it
content
also is that
exactly.
14. That is the admitted amount. By the communication with them or they are not.
Now this order was passed on 14 and you served it on 2023. PHC. Where the PHC council? Then yes, PHC. Is an application filed alleging willful and deliberate violation to the order dated 14/8/2023, passed in WPC number 6424/2021, whereby this court directed the respondent authorities directed the chief engineer, PHE, water, and additional chief engineer, PHE, to make arrangements seeking necessary budgetary allocation so that the petitioner be paid the amount of rupees 20,31,817 within a period of 6 months from the date the certified copy of the order is served upon the chief engineer, PHE. It is seen that in pursuance thereto on 29/9/2023, the certified copy of the order was served upon the chief engineer, PHE. Thereupon also, the payment was made, and under such circumstances, a legal notice was issued on 17/5/2024. The record further revealed that on 7/6/2024, upon receipt of the legal notice, the chief engineer, PHE Water, have written a communication to the executive engineer, PHE. However, thereupon also no payments have been made for which the instant contempt application had been filed. It is seen that this court had issued notice on 2/8/2024, but till date, none has appeared on behalf of the respondents. Be that as it may, this court therefore requests Mr. I. Botaku, the learned counsel who appears standing counsel of the PHE department, to obtain instruction as to why the judgment and order dated 14/8/2023 in WPC number 6424/2021 have not yet been complied with. As to whether the judgment and order dated so and so, passing so and so, have been complied with. And if not, why there has been no compliance. An extra copy of the instant contempt application be served upon Mr. I. Thakur, the learned standing counsel, during the course of the day. This court further observes that on the next day, further observed that on the next day, Mr. I. Thakur, the standing counsel of the PHE, shall obtain the necessary instructions and place it before this court. List this matter on 8th of June 2026. The name of Mr. I. Thakur, standing counsel of the PHE, is shown in the cause list. Okay. In this order, he gets this order manner, later penalty by manner, and this penalty dismissed by the former.
So that's it. As per my instruction, the process has been initiated to pay the PVC amount of
How much?
94,000, 94 lakhs, 59,895.
When? You are appearing for whom? Huh? What is your instruction? Judgment was passed when?
Order was for 14/3/2025.
Then
Appeal was,
why haven't you complied with?
Lordship, appeal was pending, Lordship, and appeal was pending.
Now to appeal, have you gone to Supreme
Appeal,
Court?
yes, Lord. On delay ground, Lordship.
Northeast? Frontier Railway, they have money or not?
Manager, Lordship, sometime is required because process.
You want that one train? Mr. NNB Chaudhary, you want a train? Take a train. Give him the Kamrup Express or Brahmaputra Mail. Huh?
Last order.
Last order? Last order is 27/3. That is there.
Sometimes required to.
Miss R.
Add.
RDB, the learned counsel who appears on behalf of the respondent numbers 1, 2, and 3 submits that in pursuance to the judgment and order dated, what is the appellate order?
17/3.
17/3/2026, passing I number,
I number my lord 1390/2025.
and so by the learned division bench of this court, thereby confirming the judgment and order dated 14/3/2024, passing WPC number 4297 of 2023. Steps are being taken for making payment of the PVC claim of rupees 94,59,895.80. In that regard, she has placed a communication dated 18/4/2026, issued by the Deputy Chief Engineer of
Conception.
Northeast Frontier Railway, Alipurduar Junction, which is kept on record and marked with the letter X. Taking into account the same, this matter again on 3rd of June 2026. It is observed that as the amount has already been determined in terms with the directions passed by this court dated 14/3/2024 in WPC number 4297 of 2023. 25, no, 24.
So.
Asking WPC number 4297 of 2023. If there is any delay in payment beyond the date fixed by this court would be constrained not only to initiate contempt draw contempt proceedings against the respondent contemners, but also would be passing consequential directions for interest, which would be recovered from the salary of the erring officials. I think with this, I think we will.
Step number 11 में लगता है operative person is page 30.
What is the matter about?
Contractor work. So,
What department?
one, the department, housing and urban affairs.
Who is to pay?
Urban water supply and civil.
Is it there?
By the housing and urban.
Verification done.
The verification was immediately done by the department, the direction was given to the verification to the dispute, the amount was disputed by the department. The amount was disputed, Lordship.
Where is the affidavit?
Lordship. And appeal for finance.
Then who is paying for whom? NNP is not a party here. A solely appears for response number 2. M Bora appears for response number 1. Anyway, 1 and 3 is not represented. We ask this person to appear 1 and 3. Who is this? Kavita Padmanabhan, and the other is the Dr. Praniti Gupta. They are not being represented by councils. I hope. Well, 3 contempt applications have been filed alleging willful and deliberate violation of the orders passed by this court. It is seen that as far back as in the year 2025 itself, June 2025 itself, the respondent numbers 1 and 3 sought for time for filing affidavit, but there has been no affidavit filed. Apart from that, the counsel who was appointed by the respondents to represent them have also not put their appearance. It therefore appears that there is not only non-compliance to the order passed by this court, for which by this court, but also now tell me one thing, which is your order?
Page 11.
No, wait. Item number 115/2025. What is the direction? 16.8. 16.8. All are 16.8.
Six. Repetition numbers are different. Contents.
They're not only amounts to violation to the order passed by this court, but also giving scant regard to the directions so passed. There is also no affidavit filed. In spite of taking time from this court. Accordingly, this court directs the listing of these 3 contempt applications on 22nd of May 2026 at 2 p.m. At 10:30. 10:30. The respondent number 1 and the respondent number 3 are directed to put in their appearance to the video conferencing link to be provided by. You can provide it? Let us have it on 8th of June 2026. And the respondent number 1 and 3 shall appear either through the video conferencing link, which the respondent which the registry shall provide or shall appear in person at 10:30 a.m. and answer as to why initiation contempt proceedings should not be initiated against them.
Operative order by the para, page 23, my. I filed wakalatnama for the sole respondent matter.
Huh?
I filed wakalatnama for the sole respondent matter. And as per my instruction, they file appeal matter against the order appeal order. So
Okay.
sometime maybe given matter. Either. Appeal was withdrawn. Not withdrawn, looking the order. And after my settlement order was set aside, directed to make it lot, lottery, but they again extended my that's one that time. That was filed by the municipal. That was withdrawn by the private party. My lord, that was withdrawn by the private party. This was filed by the corporation. Board, my lord, municipal board. My lord.
It was filed on 18th.
Yes, ma'am. So sometimes settlement order was set aside. They have directed to the lottery and they after they extended my lord. Extended that's my lord. Settlement order again.
Okay. They filed an appeal. Yes. It has been submitted by Mr. Estoto, the learned counsel who represents the respondent,
Sole respondent.
that an appeal has been filed by the respondent on 18/3/2026, challenging the judgment and order dated 17/2/2026, passed in WPC number 5076 of 2025. So he therefore submits that some time may be granted till the appeal is listed and some orders can be, some interim orders can be prepared. Taking into account the above listed matter on 8th of June 2026 for an update. In the meantime, if the appeal is, if any interim orders are passed, the same be placed before the court by the learned, any interim order is passed by the learned division bench of this court, the same be placed before this court. Otherwise, the respondent shall bring on record the stand by filing the affidavit on or before 1st of June 2026.
Smart. I know. Today, and they have also filed an indemnity application for negligent order. So I may be allowed to stand and reply.
What is the order? The order dated 11/3/2026.
11/48.
Huh?
In the mistake, page 40.
What are you? Huh?
Order include, madam?
Where?
No, order passed by the
11/3/2026.
Page 40.
first 40, picture 9.
Now tell me, how can this order be stayed?
Well, technically the interim order is just based on document.
Understood. My question is, you'll be today asking for extension. The interim order is till today.
Yeah.
Why should I extend it? Because staying this order amounts to allowing your reputation. This is the order you have challenged.
Yeah.
How is it possible?
But
Forget about their eye, not on their eye.
in fact,
You argue on the bail.
but my society has been operating. But
So what? My question is, Mr. Islam, if I stay this order, am I not allowing the repetition at the interim stage without giving them an opportunity to file a response? There are serious allegations against you, not by everybody. So why should we extend this interim order?
well, that at the time of the passing the interim order,
Let us see the order which was passed on 19/3/2026.
My alia मला by this court.
See, you have been asked to continue.
Yeah.
You see, kindly come to paragraph 4 of the order passed by the learned court bench. When a notice inviting tender was issued by the respondent number 4 subsequently on 38/2024, inviting application from interested handling and transport contractors for appointment as handling and so and so for South Salma, Mankasa district. The said NIT was put to challenge by the petitioner society, along with others in with petition being so and so. Afforded banks while issuing notice by an interim order dated 15/10/2024 had observed that the NIT dated so and so shall not be acted upon till the decision is taken by the division bench in the batch of appeal with appeal number so and so. He is one of the appellants in the said batch of writ appeal by an interim order dated so and so. How is it possible both are going together?
My lord, our submissions, my lord.
This is a notice inviting tender, and it's a 3.
but notice has been invited and subsequently appointed a private person.
Understood.
That was
Now, see, this is the nature for the year, city council for the year submitted, but state cannot employ private contractors for transportation of essential grains from so and so. In view of this, before the submitted, it is under such circumstances, there was a stay. Further status quo was directed to be maintained in respect to the existing demand insofar as the transportation of AIs in the next state. On perusal of the contents of the petition, this court finds that the issue to decided is pending before the division bench of the appeal number so and so. In view of the division bench of this court directing that the lifting area from the designated report should be carried out as per the existing system of distribution. This court is of the view that this happened in 2018. How is that have any relevance here?
My lord, the respondent of the IA, my lord, he checked, my lord, that
So
none of
it
the,
does the learning
none of the
hearing
litigants, my
on
lord.
behalf of the state RCT, having regard to the area and the appellants are continuing to lift and distribute food raised from the designated reports, we direct the parties to maintain status quo in respect to the existing system of distribution insofar as transportation is concerned in the final decision in the appeal. This is nothing. This is an allegation, serious allegation against you. We cannot allow such.
So, then inquiry has been done behind my back, but
Well, he was
What?
given chance to.
I may be give some time, I will file a reply and
I'm not extending the interim order.
the registration may be
This will be allowing the repetition. Sorry. Heard Mr. R. Islam, the
Just
learned
after
counsel
one
appearing
week,
on.
This matter may be picked for an hard and finally.
Huh?
Matter may be picked for it after 1 week and hard finally in the.
Understood, they will let them file the affidavit in the
But they have
meantime.
filed, madam. Already affidavit filed today. Today I have received.
You file your reply, but I'm not extending the interim order. Sorry. Because this interim order, I will dispose it of. It may be in your favor, but the ground on which you are doing it is in, because these are separate grounds. You may say that it is invalid, the ground on which the stay has been granted, in my opinion, I can't extend it. My conscience does not permit. Huh?
All the writ appeals, my lord, the deponent check, the BC had, district commissioner had checked that, my lord, in the writ appeals, my lord, none of the writ appeals, his name
But
doesn't appear.
retabils we have not party, but
They are
pursuant
not
to
party,
that
that is not
retabils order,
correct
madam,
submission, my lord.
the earlier interim order has been passed.
That is not
And then
correct
pursuant
submission,
to
my lord.
that during the continuation.
That is a different thing. That is an issue is different as to whether a private contractor can become within the ambit of that. That is an issue which I have already dealt with. In fact, it has been properly dealt with by Justice UK Nair in a missed case in another matter when Mr. Topon Deori and Kane Chaudhary was on the other side, and the other side here Mr. Deenath was appearing on this side. And there was another contractor who was appointed. And thereupon they went ahead and went to go for a cooperative society, because it is either by the cooperative society or the government by themselves who can lift. Now, here, you are concerned out here now.
For a cooperative society,
You are a handling contractor, maybe, but the allegations which are made against you are serious.
And now, my lord, the other, that, my lord,
We are not
cooperative
concerned.
societies are lifting the, my lord,
1 week time may be given. I have to file a reply. This decision may be
Reply
taken
for what?
finally.
Reply for what? But I'm not, but you have to satisfy me. Answer to this. If I stay this order, wouldn't it be allowing the writ petition? Is it such a nature that it would grossly affect you? Yes, you may be, but we can earlier disposal of the writ petition can be done, but not on the basis of this. Sorry. Affidavit filed, you file reply.
Immediately they have filed, my lord.
Very good. You file reply.
But after 1 week, my lord, I will
You
file the
after
reply,
one.
but in the meantime,
But-
the entire petition may be disposed of.
Very
After,
good.
just after 1 week.
But I'm not extending the interim order. As I'm not extending, she is going to withdraw the IA.
Lordship, because my lord order was there, so on the same day itself, my lord, it was allocated to all the GPS cooperative societies, my lord, 10 cooperative societies are there. So now they are lifting, my lord, and distributing the.
One existing order is there of the honorable court, my lord.
What? No, that is on a different subject matter. I don't understand that subject matter. You see, the subject matter of that writ petition is as to whether
Yes,
a
but
private contractor
can be appointed.
can be appointed, which is in violation of the rules. That particular safety, some
Yes.
rule is there. Now, what is the name of the rule?
But that the rule, order
This
7
one,
1
the
7
Targeted Public Distribution System Control Order 2015.
Yes.
So there, order 7-1, 7-11, 8-1, 8-3 of the targeted N2G categorically says that it has to be either by an authorized agency. Authorized agency would be either the government by themselves or a
By the
cooperative society.
cooperative.
That law is clear on that. That is a matter for that. How this matter have any connection? Here there is an allegation of you the troubling all these other the GPSs. Serious.
Not travel, my lord.
No, this is a very serious
This
issue.
inquiry has been done, my lord, behind my back.
And
they
very
have
well,
absolutely
we will set aside that or whenever it is, but not today. I am not going to. You want? Yeah, where is it? Where is the allegation that there is inquiry behind your back? Where you have filed an affidavit?
Yes, my
Right,
lord.
just file, my lord.
Let us see whether inquiry. Then I'll dismiss your petition right away. Go to the writ appeal.
And-
But the order which was passed is very appealing. So was notice was also issued.
That shows notice I have.
Islam, if there is a so-called notice, I have not seen here. I have not seen here till now. If the so-called notice has been issued, you made a submission before this court that it was done behind the back.
That I have.
Then in that case, this is a case of cost. Use first.
My lord, in IA, I have.
Chairman, clarification regarding lifting.
My lord, now the present secretary has, my lord, he has been, my lord, withdrawn himself, my lord. Now another secretary has been, my lord, appointed. Now he has, my lord, given the affidavit that he is going to withdraw this case, my lord. Now he is not the secretary here, my lord. New secretary has been appointed. So what I have annexed in IA.
Who is Ziaur Rahman?
The secretary of the
He now,
present.
Ziaur Rahman is now present in my society.
Huh?
Ziaur Rahman is the secretary of my society.
And you have to withdraw the earlier requisition 1650. This one,
Present.
your secretary wants to withdraw. This is
No,
it.
no, not to program.
No, but
Now, my lord, the
He
chief secretary has been appointed. So we
that-
have filed an
your entire petition is based upon his affidavit.
Yes, ma'am.
How your petition can survive?
But he has been resigned from the post. But we are also already appointed another secretary.
Oh, that is then I cannot.
He's not agreed by the.
I submit the withdrawal of petition before the honorable register to withdraw the petition that I am acquainted with the content of so and so. What is do the petitioner is so and so, I am the petitioner of so and so. Yeah? Which charge so and so. That of thing cannot.
Well, let the matter be fixed and after 1 week, my lord. And on that day, my lord, the entire matter may be disposed.
And in IA, my lord, I have annexed.
Now only I am disposing of the entire matter, dismissing your petition.
Why?
She is not going to insist on the I.
No.
No, so now you argue on yours. Who cares? I hope heard Mr. R. Islam, the learned counsel appearing on behalf of the petitioner. Miss so and so appears on behalf of the respondent number. Union of India, SS Roy appears on behalf of the respondent number 1, Miss. Uda, the learned additional senior government advocate appears for the respondent number 2 to 6.
No, my lord, 6 years.
To 6. Who appeared for these other people? Steps have been done.
Private, second.
Notices have been issued upon the other respondents. However, there is nothing mentioned in the office note as regards service having been meted out upon the said respondents. The present petition has been filed by the petitioner assailing the order dated 11/3/2026 passed by the Office of the District Commissioner, South Salmara, whereby on account of the allegations made by the private respondents in the instant proceedings, directed that all the private respondents, all the GPSS of South Salmara Mankasa district shall undertake individual lifting and distribution of the allotted PMGKAY rice from the month of April 2026 from the FCI FSD strictly as per the government allocation and in accordance with the prescribed norms, guidelines, and statutory provisions governing the public distribution system and submit arrival report to the department. By the said order further, on taking into account the various allegations which have been taking into account the various allegations so made, it was opined by the Office of the District Commissioner by the district commissioner, South Salma. On account of various allegations made by the private respondent as well as by the divisional manager for a Food Corporation of India, Bongaigaon. It was opined by the district commissioner, South Salma, that there were lapses on the part of the petitioner. This court further takes note of that pursuant to the issuance of the said notice, further takes note of that the instant in the instant petition, the instant petition has been filed by the petitioner through its secretary, Jiaur Rahman, and the contents and allegations made in the instant petition is supported by an affidavit filed by Sri Jiaur Rahman. The record further reveals that a communication was issued by the registered judicial Gauhati High Court from Sri Jiaur Rahman on 19/4/2026 that he may be permitted to withdraw the petition inasmuch as the petitioner have, inasmuch as the said Jiaur Rahman had tried his best to contact the engaged counsel, but the engaged counsel could not be reached. It is further stated in the said communication issued to the registered judicial that the said petition may be permitted to be withdrawn. In that regard, the said Jiaur Rahman had also filed an affidavit before this court dated 19/4/2026 that he wants to withdraw the instant writ petition. This court further takes note of that the issue involved in the instant writ petition pertaining to the challenge to the order dated 11/3/2026 have no relevance to the order passed in WPC number 1230/2026 or to the writ appeals which have been pending. It is very pertinent to take note of that the petitioner is not an appellant in the 4 writ appeals, being WA number 297/2018, writ appeal number 240/2018, writ appeal number 249/2018, and writ appeal number 12/2018. Apart from that, the issue involved in WPC number 1230/2026 wherein the petitioner is the party in WPC number 5313/2024, wherein the petitioner is the party. You are a party there?
Yes. Serial number 4.
The issue is completely different in as much as the issue involved in the said proceedings is as to whether a private person who would not be an authorized agency in terms with section 2, clause 2G of the Targeted Public Distribution System Control Order 2014 can be allowed to be a handling contractor in terms with clause 7 of the said order of 2015. It is further seen that the issue involved in the instant proceedings is on account of the various complaints made by the various cooperative societies, along with the division manager of the FCI, wherein various lapses have been pointed on account of the functioning of the petitioner. It is the opinion of this court. It is the further opinion of this court that staying that passing any interim directions in respect to the order dated 11/3/2026, thereby staying it would amount to allowing the writ petition without granting an opportunity to the respondents to show cause. This court have also taken note of that the affidavit in the meantime has been filed by the respondent numbers 2 to 6 and 2 to 6. First, in that view of the matter, today, in view of the matter, taking into account that the order dated 19/3/2026, interim order passed on 19/3/2026 was only valid till, was in operation till today, this court is not inclined to extend the interim order dated 19/3/2026. First. Next. This court have also taken due note of that the person who had filed the affidavit on behalf of the petitioner is no longer seeks to withdraw the instant writ petition, and in that regard have filed not only an application before the judicial of this court, but also an affidavit which have been enclosed to the records. Considering the above, this court fixes this matter on 1st of June 2026, on which date the maintainability of the writ petition shall be taken into consideration as to whether the maintainability of the writ petition would be taken up for decision, adjudication, as to whether after the deponent of the affidavit having withdrawn or wished to having withdrawn after as to whether the instant writ petition is maintainable in view of the withdrawal submitted before this court by Sri Jiao Rahman, who had filed the writ petition and had supported the contents of the writ petition by way of an affidavit. Ms. Yudas, the learned standing counsel appearing on behalf of the applicant, submits that the petition applicant would not like to insist on the instant application in the application stands.
We have enclosed all the so-called.
Submits, well, that the said application may be kept on record for the purpose of deciding the writ petition.
That may be treated
Taking
as
into account the above, taking into account the above, the instant application stands closed. However, the records of the IA be tagged along with the writ petition for future adjudication of the accompanying writ petition. Yes, Mr. Bora.
May I please your lordship? My lord, the limited prayer of the petitioner is that, my lord, he has been debarred. My lord, he has been prevented from participating in a particular tender process.
Right, we did.
Yes, my
You are
lord.
also now having problem.
Lordship, in
Earlier it was
Lordship,
only
kindly see the
Mr. Upadhyay, earlier it was only restricted to the PWD. Now you have also.
Yes, that has not been intentionally issued to the petitioner, my lord. preventing him from participating in the tender.
That thing is not that notice of inviting tender was issued on 13/3/26 law. The petitioner came before the court on 4/4/26, last date of submission.
My lord,
Last date of submission of the tender.
Now submission is over.
Oh, God. It was till 4/4 to
Have you opened the technical bit?
no, my lord, it has not been opened.
Yes, but mine substance not open due to the code of conduct.
Then you do agree. It is not so. Go and visit and have you visited?
Yes, my lord.
Where you visit?
My lord, annexer to page 83, my lord.
Huh?
Page 83, my lord. I approached the authorities, page 83 and page 84, my lord.
83.
And page 84.
Now, why you are 83? Why you are directly writing to the chief minister, the authority?
He, for 1 week, he was running, my lord. He was running after the concerned executive engineer for 1 week.
No, I'm not concerned. Where is the, with reference to it is something they kindly requested to be measured for issuance of the year. Now, this was given on 1/4.
Yes.
Now, at the time when you are giving it, you are to give along with some there is a requirement of submitting with geotechnical area or something.
Yes,
where,
my lord.
where are the photographs that you visit?
No, that has to be, my lord.
No, where are the photographs?
That has to be taken in presence of an authorized representative deputed by the concerned executive engineer.
But how
Page
can we help you?
page 26, my lord. Page 26, my lord, it says that, my lord, prior to bidders or authorized are required to visit the project site to obtain a
Page?
page 26, my lord.
Where?
Uh,
Prior to submitting the bid, bidders or authorized representatives are required to visit the project site to obtain all necessary information for preparation of the bids and execution of the all costs associated with that shall be borne. The bidder must submit a site visit certificate duly signed by the bidder or authorized agent and verified by the concerned executive engineer.
Yes, my lord.
Now, where is it? You asked on 1/4.
28/3/10/14, my
Now,
lord.
28/3 is to the chief minister.
Yes, my lord, he directed, my lord, the concert
Where is your 28/3 document?
page 83, my lord.
83 is addressed to whom?
Chief Minister, my lord, the Honorable Chief Minister directed the concerned
My
engineer.
goodness, you write to the chief minister for a site
Because-
visit certificate.
For 1 week, he was running after the engineers, my lord, and ultimately
So
on
you-
1/4,
Forget about that. Have you submitted the document to them?
my lord, that photograph, because there was earlier round of tender process also, and during that process, he did all the formalities. If your lordship peruses annexer 587, in that
So you
process,
mean to say the chief minister allowed it?
yes, my lord, he directed the concerned chief engineer to take that. And
Then?
subsequently, the petitioner approached the concerned executive engineer also, paid
And
later,
what did the chief engineer do?
chief engineer directed, my lord.
Where is the chief engineer, the direction?
No, that is not there, my lord, but thereafter he approached the concerned executive engineer also on 1/4, my lord. That has been duly received, my lord, page 85. Page 85,
Who
my
has
lord,
received this?
page 85.
Who has received this?
The one of the officials in the office of the concerned executive engineer, my lord.
But have you visited?
My lord,
My question is, have you visited?
he has visited, but he has to be accompanied by a
No,
representative.
forget
my-
about that. Have you visited? You have
Yes,
not
my lord, I
visited.
have visited. I
Where?
have got photographs.
Where is
of-
your statement that you visited? Show me the photograph.
My lord, let me submit one thing, my lord.
Show me the photograph.
In respect of the same
No,
words, my
Mr.
lord.
Counsel, no, Mr. Counsel, this time you
Just
are
give me one minute.
You do one thing, for a site visit certificate, you can approve the chief minister. Why filing the petition?
My lord,
Go
in
directly
respect
to
of
the
the-
chief minister.
Lordship and
In
Lordship,
respect of the, my lord,
on the last date of submission of the tender, note, submission.
my lord,
On the very last day, he has approved. We have waited till Lordship.
It's okay, but then also I would have allowed, I have allowed many that submission later.
my
on
lord,
also I have
kindly
allowed.
peruse,
But- Where have you mentioned that you visited the site?
kindly peruse page 87, my lord.
Now, where have you mentioned
lord,
that you have visited the
I'm
site?
coming to that.
No,
my
no,
lord.
come
Page
to that. No,
87,
Mr.
my lord.
No, Mr.
In
Vora.
respect of the same words, my lord, earlier there was a tender process, page 87. He has been after opening of the financial bid, the petitioner was adjudged L1, my lord. So that photographs, everything was with him, my lord, because during that process, kindly period 87, my lord. Page 87, in respect of the same work, my lord. The petitioner was adjudged L1 after opening of the financial bid. Then, so that time he visited and he had all the photographs, my lord. Because the tender terms and conditions were same. So petitioner was adjudged L1, my lord.
Where are those documents?
Those documents are there with the petitioner, my lord.
Why haven't you filed them?
My lord, because it is in respect of subsequent tender process, but in
That
respect,
means you also acknowledge that those documents have no value.
yes, my lord. That's why I'm seeking for fresh site visit certificate.
Yes.
But that proves
Today the
that
matter has come up for what? Order. Order.
my limited prayer is that, my lord,
Notice upon respond number 4 by Dusty, no affidavit has been filed regarding Dusty. Since the notice has been issued, we make sure this take is asserted, take us away. Hence the matter is fixed. So, we have not done it properly.
my lord, my limited prayer is that, my lord, he may petitioner just seeking to submit his tender, my lord, with the field visit certificate. Let them issue a field visit certificate. That is the limited prayer, my lord.
Sir, where is your statement that you have earlier visited?
Page 87 indicates, my lord.
Where is your statement in your petition?
My lord, he has to visit along with a representative of the executive engineer. So along with the representative, they have to take a photograph, my lord.
Where is it mentioned?
As per the procedure of a site visit certificate, my lord, it says that, my
Where is
lord,
it mentioned?
clause 6, my lord. All process bidder or authorized representatives are required to visit the project site to obtain all necessary information for the preparation of their bids and execution of the contract. All costs associated with the site visit shall be borne by the bidder. The bidders must submit a site visit certificate duly signed by the bidder or authorized representative. So authorized representative, my lord, he has to accompany the bid. So that after taking the photograph, then he will verify. Because alone the petitioner cannot go and
Mr. Bora, do you think this court doesn't know this aspect very well? Do you think that you are making a fool of this court? Or authorized representatives is what? The bidder or his authorized representative?
yes, my lord.
Then
Yes, but that has to
there's
be
no statement out here. We don't have the case. Oh, your chief minister can help you.
and verified
For
by
a site
the,
visit certificate, you approach the chief minister, then you go there.
my lord, otherwise kindly appreciate one thing,
No case.
otherwise why
sorry,
you will approach
please,
before
please,
your
please.
lordship, my lord.
No case.
Otherwise, why you will approach it?
No,
Because he is
Heard Mr. DP Bora, no case.
intention, he is only to participate in the tender process, my lord.
So today the matter has been fixed. Yes, what is your stand?
See, I have not filed my affidavit.
You want to file an affidavit?
In that case, I file my affidavit. I will file my affidavit.
Otherwise, my lord, why?
Mr. So-and-so who appears on behalf of the respondent numbers 1, 2, and 3 submits, he would like to file an affidavit. It is also seen that no steps by way of Dusty has been taken upon the respondent number
My
4.
lord, it is under.
Further to that, the notice was issued by Speed Post only on 22/4/2026. Considering the above, the service is not complete as regards the respondent number 4. List the matter upon service being complete upon the you do better bet why you going to file an additional affidavit. But Mr. Bora, this type of argument don't make it before this. Don't take this court that this court doesn't know what it is. I've been dealing with the site visit certificates for a long time. Here is a case. What is required to be? You have to file an affidavit. Then look here, I have earlier visited also. This is my site visit certificate. That may be taken into consideration. I could have very well passed this order. But you are not doing it. You are trying to make a fool of this court and say the authorized representative. Mr. Bharat, I take exception in making this type of submissions.
My lord,
Either you may be a fool out here to make this type of submission, or you consider this court to be a fool, not to
my
understand.
lord, within.
Don't make this type of submissions. Allah kita buat likit di betul.
Within 2 days. my
Don't
lord,
make
I
these
filed
submissions before.
Filed the affidavit, my lord. My lord, within 2 days, I will file the affidavit, my lord. I have got that photographs, my lord. Within 2 days, I undertake, my lord.
You can get an order in your favor,
My lord, I undertake,
but you want to make this court look like a
my
fool.
lord, I
And say,
undertake.
you do one thing. Whenever Mr. Debora appears, put it in also in Assamese. Whenever he is going to appear. Don't you understand the basic English language at clause number 6, which categorically says the petitioner or the authorized representative? Then,
My lord,
and you say that the authorized representative of the department has to go.
my lord, within 2 days, I will file the affidavit. I undertake, my lord. Because in respect of the earlier tender process, I have got the photographs, my lord. I undertake to file it within 2 days, my lord. Your lordship may take up the matter on in the next week.
You see, many orders have passed in this favor, but you are one to try to make a fool of this court.
I undertake to file it within 2 days, my lord. Within Monday, my lord, because the Friday, Saturday, Sunday holiday, on Monday I will file it.
File it tomorrow.
Yes, my lord. Yes, my lord, by tomorrow.
Heard Mr. D.P. Bora, the learned counsel, appearing on behalf of the petition. Both of you, black book. Learned counsel appearing on behalf of the petition. Mr. N. Upadhyay appears on behalf of the irrigation department. At the outset, the learned counsel appearing on behalf of the petitioner submits that the petitioner would not insist upon proceeding with the instant proceedings against the respondent number 4, and the name of the respondent number 4 may be struck off. Taking into account the above, the name of the respondent number 4 is struck off. The petitioner is directed to file a fresh memo of parties before the registry of this court by Monday, and the registry shall make necessary changes in the cost title and update the same in the CIS. The learned counsel appearing on behalf of the petitioner further submits that in that view of the matter, the service is duly complete. The learned counsel appearing on behalf of the petitioner submits that this is a retender. The present tender proceedings is a retender, in as much as in the previous tender, which was issued for the same work, the petitioner had duly visited the site and was issued a site visit certificate. He therefore submits that this phase, the learned counsel therefore submits that the very concept of a site visit certificate is only for the purpose of ascertaining as to whether the petitioner had, the bidder had visited the site. And this particular, the site visit certificate, which the petitioner obtained earlier, may be permitted to be used for the purpose of the tender in question. Full stop. The learned counsel further submits that he may be permitted to file an additional affidavit bringing on record the site visit certificate along with the photographs, which was filed which was submitted in the previous tender in respect to the same work, where the petitioner was adjudged as the L1. Liberty is given to the petitioner to do so. The learned counsel further submits that in the meantime, the technical bid may not be opened, inasmuch as if the technical bid is open, this would result in multiplicity of proceedings. Mr. N. Upadhyay, the learned counsel submits that in view of the ongoing model code of conduct, the technical bid had not yet been opened. Taking into account the above, this matter on 6th of May 2026. In the meantime, liberty given to the petitioner to file an additional affidavit bringing on account, record the site visit certificate as well as the photographs taken on or taken. The said additional affidavit be filed on or before 4th of May 2026. List this matter again on 6/5/2026 for further consideration. In the meantime, this court further directs the respondent authorities not to proceed with the evaluation of the technical bid of the in pursuance to the said notice inviting tender, or may proceed with the same but without insisting on the site visit certificate from the of the petitioner.
He has not submitted the bill. Not submitted.
My lord, I have stated in the petition, my lord.
He has not submitted the bill.
My lord, because of the, he could not submit, my lord.
You could have, there are many people who submit.
Yes, my lord, but my prayer was to.
No, now you cannot do.
Yes, my lord, I understand, but my prayer was to submit more offline bill along with, yes, my lord.
Yeah, that can't be done. That will be cancellation of the.
My lord, that, because technical bit has not been obtained. I may be allowed to. submit.
Understood, but you can't be given because that he tenders.
Yes, my lord, but offline bill may be permitted
No,
by your.
that is not permitted. It has, you can go for England. Then you can't help you. You can't do that. पहले एडिशन एप्लीकेशन के लिए देखो यार, this is the matter on 6/5/2000. You see, but you can't do it. Like interim models can do it.
Right, my lord.
Those steps, why?
Why not, study we have taken the steps upon
Huh?
respondent number 2, my lord.
What?
My lord, upon the respondent number 2, my lord, yesterday I have taken the steps, my lord. Earlier you also took the steps. That was not done.
I don't put in no such steps have been taken by the commissioner for issuance or no respondent. Which respondent?
Number 2, my lord.
Who is respondent number 2? Outside who appeared?
Managing director of high school, some choices. Other have to let and find out. Happy to be good.
Why haven't you taken steps upon respondent number 2?
My lord,
Why haven't you taken steps? Who is to pay the money?
my lord. Cooperate.
The present petition has been filed today on account of steps not being taken upon the respondent number 2. It is seen that on various occasions, the matter came up before the respondent, before the Lozima court, asking the petitioner to take steps by way of upon the respondent number 2. The learned counsel appearing on behalf of the petitioner submits that the such steps by speed post would be taken during the course of the day.
My lord, already taken yesterday.
Have already been taken on.
Yesterday, my lord.
No, now. Be taken within 7 days. List the matter upon completion of service upon the respondent number 2.
This was issued on 25/9, returnable on 12/1.
We have not received the extra copies.
What?
Extra copies have.
But it has come for orders for.
No steps for issuance of notice received.
So the office note says that no steps have been taken before the registry. Extra copies was handed over to the.
No, Mr. Mukherjee, you have joined yesterday. Then you know what is to be done.
That was done.
Have you taken the steps and then filed it? Why? It is seen that no steps have been taken by the petitioner pursuant to the order passed by this court on 25/9/2025. It therefore appears that the petitioner does not have any urgency in the matter Considering the above, this court directs the petitioner to take again steps as directed by the order dated 25/9/2025 upon all the respondents by serving extra copies upon all the councils and thereupon file the necessary document. List this matter on 14th of September 2026.
The course of the case.
Okay, leave the matter on 7th of December 2026. 14 September. In the meantime, the respondents shall bring on record their stand by filing them. What is this?
My lord, filing for implement of parties, my lord, transaction mission.
Implement of whom? Okay, this is an application filed for implement of the respondent number, opposite party number 4 and 5 to the accompanying contempt application. Accompanying with petition. Puस्तक. Taking into account the stand which have been taken by the Water Resource Department. It is the opinion of this court that the presence of the respondent opposite party number 4 and 5 would be necessary for the purpose of proper adjudication of the accompanying writ petition. Accordingly, the opposite party number 4 and 5 herein are pleaded as the respondent number 4 and 5 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of party within 7 days. List the matter and an ISN's closed. As regards the Union Council, no council. Yes, Mr. K. Gogoi, the learned counsel, learned CGC accepts notice on behalf of the newly impleaded respondent number 4 and 5. Extra copies of the number issue notice upon the newly impleaded respondent number 4 and 5 returnable by 7th of September 2026. Mr. K. Gogoi accepts such notice. Extra copies of the writ petition be furnished by tomorrow. The respondents shall bring on record their stand by filing the affidavits.
The completion of the works lordship. Work issued in the year 2015 lordship and work is completed in the year 2017 lordship.
Yes, now what do you want? You are asking for a security report. Now he is saying that you did not complete the work.
183 of our.
So work completion certificate issued by the petition.
Is one,
Work completion certificate issued by the. Yes.
So go there before the civil court.
Madam, taken action against those officers also, madam. 183, madam, take 183 of our affidavit.
Heard Mr. N.J. Gogoi, the learned counsel appearing on behalf of the petitioner. Ms. Yudas appears on behalf of the respondent numbers 1, 2, 4, 5, 6, 7. Hold on, 1, 2, 4, 5, 6. Mr. Arbor Pudari appears for the respondent number 3 and 7. The petitioner herein is aggrieved by the non-release of the security deposit after completion of the work
Work order detail of
for the completion of the work, but relating to upgradation of GB Gore Fish Farm Roha in the district of Mogao under RIPF Roman 2019. It is the case of the petitioner that the same work have been duly completed And under such circumstances, and completion certificate have also been issued. And under such circumstances, the security deposit of the amount of rupees 13,22,006 is required to be, ought to have been released to the petitioner.
It's not complete two of stuff, no pay and no bill.
And our stand is, my lord.
How much you are asking for?
Total amount is, I have deposited 13,22,066 rupees for two works. It's a complete two works.
Completed two works. And as such, is entitled to the return of the security deposit, which was made in respect to the two works, to the tune of rupees 13,22,006.
That we have.
The respondents have filed an affidavit on
My lord, on 9/12.
9/12/2025, wherein it has been mentioned that preliminary inquiry was conducted by the officials and the Director of Fisheries in the light of the complaint dated 5/9/2000 issued by the RTI activist Sri Dulal Bora. And upon such inquiry being conducted, it was found that there was prima facie evidence against the petitioner of misappropriation of 44 lakhs 39,000.
I have received excess amount.
Fraudulently received.
It is their submission. You see, kindly come to paragraph 5, mentioned there. States when so wherein revived and by recalling the order here, paragraph number 3. Where initially inquired a team official under the principal accountant by association wherein prima facie evidence of year was detecting, covering 3 sub-estimates out of 17 of the sub-estimates under package A executed by the petitioner. Pusto. It is also mentioned that there were further inquiries being carried out, wherein it was found, there was prima facie evidence found of misappropriation of rupees 15,84,684 in sub-estimate number 6 and 9 under package B and C. And based upon such inquiry, the Director of Fisheries was requested to take follow-up action against the defaulting so and so. It is therefore the case of the respondents in the affidavit that rather that the petitioner is not entitled to the amount of rupees 13 lakhs so and so as have been sought for in as regards which relates to the deposit of security deposit by which relates to security deposits submitted by the petitioner. Rather, the respondent authorities are entitled to certain amount from the petitioner after deducting the said amount.
That's what we want.
It has been mentioned that the respondent authorities are entitled from the petitioner an amount of rupees 27 lakhs 41,829. So from the stance so taken by the petitioner as well as the respondents, it appears that the issue involved in the instant proceedings amounts to the proceedings would require factual adjudication as to the entitlement of the petitioner, who are the claims so made by the respondents against the petitioner. These aspects cannot be decided in the proceedings under Article 2 to 6 of the Constitution, inasmuch as the same would require detailed and in-depth analysis of the evidence on which such claims are being made. Considering the above, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. This court, however, observes that it is on the ground of disputed questions of facts arising. This court is not inclined to entertain the instant writ petition. Under such circumstances, it shall not be a bar on the part of the respondent petitioner or even the respondent authorities to approach the competent court of civil jurisdiction, if so otherwise permissible under law. This court further observes that the dismissal of the instant writ petition shall not prejudice the petitioner in such proceedings. Additionally, taking into account that the petitioner have been bona fidely and diligently pursuing the instant proceeding on the belief that the petitioner, that this court would be exercising the jurisdiction. This court is of the opinion that the period during which the instant writ petition has been pending should be excluded while computing the period of limitation. Accordingly, the period from 12/1/2018 till date be excluded while computing the period of limitation for filing any proceedings before the competent court of civil jurisdiction by the petitioner. Huh?
Is that a 9/4/2021? They have annexed in the affidavit. They allow him to liberty in captive to challenge them.
That was already in the reply,
I'm only adjudicating. So, Mr. N.J. Gogoi, the learned counsel submits that the communication detail
Communication at 9/4/2021.
that he may be permitted to, that learned counsel submits that this court further takes note of a submission made by Mr. N.J. Gogoi, the learned counsel appearing on behalf of the petitioner, to the effect that the dismissal of the writ petition should not bar the petitioner to assail the communication dated 9/4/2021. It is observed that the instant writ petition pertained to the claim made by the petitioner for refund of any security deposit in respect to the two works, which on account of there being disputed questions of facts, this court was not inclined to entertain the instant writ petition. The same, however, shall not bar the petitioner to challenge the communication dated 9/4/2021 in any appropriate proceedings, if so advised and permissible under law.
I would say in the last revision, directed me to obtain instruction for external of whole lawsuit.
Affidavit filed.
What's it? I have communicated to authorities, I have not received the instruction. There's one 14 notice I have communicated to them. Some time maybe given, I will review that.
What is the stand of this person?
I don't, we do. One is that regarding the limitations matter that I raised on the last occasion, they have come very late. And second thing, my lord, that we raised that, my lord,
here is my respondent number 4, my lord, is the authority who is supposed to sponsor this schemes, my lord. We just in between, we are just a facilitator, my lord. We help with the process, the corporation. Otherwise, money has to come from them. His, my,
Because the respondent number 4 has declined. You have forwarded it, but it has been declined on account of the fact that it should not have been done through
No, no.
website.
according to procedure. That is the case.
Let's wait for some more time. Yes, the instruction from the respondent number 4. Mr. Kidwoy, who appears on behalf of the Mr. Kidwoy, the respondent and the relative is submits that in pursuance to the directions passed by this 4 from 9/2026, he had duly communicated to the respondent 90. He had duly communicated to the respondent number 4 on 23/2026. However, he has not received any instruction. He submits that some more time may be given so that he can send a reminder for the instructions as sought for by this court. Taking into account the above, this matter on 3rd of June 2026. In the meantime, the respondent number 4 shall provide the necessary instructions. The instructions as to why the petitioner would not be entitled to the remaining 50% of the amount for which the instant petition has been filed.
Yesterday, we have filed our reply.
But you didn't, you received the reply yesterday, and but you certain, you received the copy of the affidavit yesterday.
You have filed a reply.
They filed.
Yesterday, we have.
What do you want?
You thought, certain new materials have been placed by them to the affidavit. So
Your name?
NK Rajpal.
So and so appearing on behalf of the respondent number 2, 3, and 4 submits that the petitioner has filed an affidavit in reply on locality. And as certain new materials have been brought into light, you would like to obtain necessary instructions in that regard. This the matter on 5th of June 2026. In the meantime, any rejoinder to the affidavit in reply be filed on behalf of the respondent number 2, 3, and 4 on before 1st of June 2026.
Thank you.
Your Lordship, can you see ordered 30/26? My appeal is pending before the authority, and they have not heard it because I have not paid the money. Now they have calculated the amount. I will report it and then I hear my appeal.
What is your case?
Yes, my lord. Illegal conveyance, my lord, of my mining contract. Because, my lord, I have to get more than 3 crores of rupees, my lord. Because installment, this money of 10, 11, 12, 13, 14, 21, 22, these are all I deposited. But during that period, they did not issue any salan because of the COVID, my lord. But they have taken my money. But ultimately, they terminated me. So that was missing Celine. Equally, I filed a appeal report. But the appeal was not been heard because some amount of money they have calculated. Earlier, they have calculated you have to pay 32 lakhs. Then only I will hear that. Now they, last time they did a proposal before this honorable court. If they pay it, my lord, 2,87,000, then they will hear my. So now I'm ready to go.
Please instruction.
They have,
They have 28/3.
yes, that is. So in person, that my lord, I will pay that amount. They will hear my.
Heard Mr. T.G. Mohanty, the legislative council is by Mr. Enalam. Appearing on behalf of the petitioner. Mr. R.R. Gogoi appears on behalf of the respondent numbers 1, 2, and 3.
4, 5, and 6.
Huh?
4, 5, and 6.
4, 5, and 6 is also a party. Who appears for 1, 2, and 3? Oh, 1, 2, 3, 4,
5 and 6.
5 and 6. The petitioner herein is aggrieved by the termination of the mining contract of the petitioner in respect to Kalyan Minor Mineral Stone Unit number 2. It is as per the case of the petitioner that the petitioner thereupon, pursuant to the termination of the mining contract, has filed an appeal on
65. No, that means no.
filed an appeal on
Filed on 16/5/2024, madam. Page 132. 16/5/2024.
there's no list of dates in your petition.
Madam, page 132, madam.
This type of petition, I think we should reject it. No list of dates. We reject.
It is, yeah, madam. It is, yeah, madam.
Where? Read the list of dates. Where is it?
That's after.
Do you, Mr.
After-
Mohanta, do you support this type of list of dates? No, tell me, you are a Guwahati High Court counsel also.
Supporting, but here,
No, you are not supporting, then obviously the senior counsel is not supporting, we should reject it on that basis. What do you say?
My,
Mr.
my,
Babu?
it is in order.
Huh?
It is there.
Oh, it is not there.
After.
So this type of petition should not be made. I filed an appeal there on
16/5/24.
on 16/5/2024 before the respondent number 3.
Principal statement.
It is the case of the petitioner that on one hand, the respondent number 3 have not decided, passed any effective order on the said appeal. And on the other hand, the petitioner is suffering on account of the illegal termination. It is under such circumstances the petitioner has approached this court by filing the writ petition. Mr. T.J. Mohanta, the learned counsel appearing on behalf of the petitioner, had submitted that on the earlier occasion, when the appeal was filed, the petitioner was informed by the office of the respondent number 3 that the said appeal would be heard only upon a deposit of rupees 39,55,175. Isn't it? How much?
51 lakhs 19,466.
51 lakhs.
19,466.
Under such circumstances, the petitioner had to approach this court on account of such illegal demand for hearing the appeal, which is otherwise permitted by the statute. It is seen that during the course of the hearing, during the course of the instant proceedings, the Divisional Forest Officer, Karimganj Division, had intimated, they had apprised this court that the said appeal will be heard upon a deposit of 2,87,008. The learned counsel, senior counsel appearing on behalf of the petitioner, has submitted that the petitioner is willing to deposit the said amount of rupees 2,87,008, and there should be direction issued upon the respondent number 3 to dispose of the appeal as expeditiously as possible and within a period of 30 days. Taking into account the said submission, and more particularly the fact that there is an appellate remedy available. It is the opinion of this court that the petitioner should be relegated to the appellate authority for decision of the appeal which has been filed by the petitioner on 16/5/2024. 16/5, na?
Yes, 16/5.
24. Subject to deposit of the amount of rupees 2,87,008. Accordingly, the instant petition stands that stands disposed of with the following observations and directions. Number one, the appeal shall be considered by the respondent. Number three, the appeal filed by the petitioner on 16/5/2024, challenging the alleged illegal termination order dated 13/3/2024, be considered by the respondent. Number three, subject to petitioner submit depositing the amount of rupees 2,87,008. The said deposit shall be made within a period of 20 days, within a period of 3 days, plus within a period of 7 days,
7 days, 30 days.
along with 70. Further to that, number two, this court further directs that upon receipt of the said amount of rupees 2,87,008, the respondent number three shall decide the said appeal in accordance with the applicable rules and regulations as expeditiously as possible and preferably within 2 months from the date of such deposit. With the above, the instant petition stands disposed. Correct. There is the signature. Signature. We are still pursuing. Huh?
But I'll take your lordship to a year back. I'll take your lordship to a year back, when an order was passed on 4/11. First, I'll trouble your lordship with that order.
Yeah,
4/11/2025. Paragraph
411 is not a year back.
My lord, last year,
3 months back. 5 months.
my lord, paragraph 6.
Since the end of that matter, I'll pass a limited stay order till 6th. It's the BP, I'll pass a limited stay order till 6th, and thereupon on that day we'll finish it. Yes, what is this?
My lord, will allow me to read from paragraph number 6. The court during the course of the hearing inquired with my senior, the learned senior counsel appearing on behalf of the appellant, on behalf of the respondent, as to whether there was any publication of notice in respect of the taxes as well as the fees mentioned in paragraph 7 of the writ petition, which is a mandate in terms of section 68(1) of the Act of 1956, apart from the notice dated 21/2/2024, annexure 1 to the affidavit in opposition. The court further inquired as regards the procedure to be followed for the purpose of increase in the fee, and as to whether the state government had framed rules in terms of section 301(2)(x) of the Act of 1956 for the purpose of fixing the maximum limit for the fee. The learned senior counsel submits that he would ask his assistant counsel to obtain necessary instructions in that regard. This court also finds it pertinent to take note of that the state of the SAP also exercises powers for approving the budget estimate as per the mandate of section 43A of the Act of 1956. It is also seen that it is the state government who has to make these rules and formulate the procedure as per the state. In that regard, this court would require the Director of Municipal Administration, for whom so the learned additional senior government advocate Assam appears, apprise this court as regards the rules so praying for the purpose of stipulating the procedure for levying of fee, and further whether mere publication of the draft proposal of annual budget estimate can be construed to be a notice in terms with section 68(1) of the Act of 1956. Now, this was the direction by the Honorable Court pursuant to which there's an affidavit that has been filed by the Director of Municipal Administration on 12 December 2025. And in the affidavit that they have filed, they have
come up with their stand that apart from section 68 and section 148 filed by the
Respond number.
Director of Municipal Administration.
Ah.
Now, your lordship kindly takes up that affidavit. That starts from page 190, 194 onwards. 190. Your lordship has got the affidavit filed by Municipal Administration. Now, your lordship kindly see in paragraph number 2, my lord, the stand that has been taken is that the answering deponent begs to state that the Assam Municipal Act 1956 contains section 68(1) and 148(2) for levying taxes, fees and tolls. Then they have reiterated the provisions. And then in the subsequent page, if your lordship kindly sees, they have also quoted section 148(2). And then in the concluding para, they have stated the answering deponent begs to state that apart from the relevant sections mentioned in the Assam Municipal Act 1956, there are no rules framed for the purpose of stipulating the procedure for levying of fees. So section 68 and 148. But now, my lord, there is
Now, what is the impugn action is dated?
Well, impugn action was to the extent of
It is dated?
no date. They had enhanced the taxes in the month of April 2024. We got to know from paper publication in the month of June. We came before the Honorable Court. Now, to that, my lord, our grievance that was raised was that they, in the affidavit, the municipal board, through the executive officer, had taken a stand in their affidavit that the decision regarding the enhancement that was taken by way of a budgetary provision that was made, and that budgetary decision regarding the budgetary provision was hung in the office bulletin board of the municipal board, and public of the municipality were allowed to raise objections within 7 days. Now, to that, we controverted by saying that taking into account the municipal area under the then Silton Municipal Code, which is now Municipal Corporation, it was well nigh impossible for the public of the municipal area to have even got to know about the publication of the budgetary provision which proposed the enhancement of the taxes. So they were not aware, and eventually when the budgetary provision was approved by the state machinery, the public of the municipal area were taken by total surprise. Now, we, well, in this, by way of this writ petition, we beg to harp upon the fact that the procedure that was followed, that was not in terms of the provisions of the Assam Municipal Act. Now, in the Act, your lordship, my lord, in the previous orders, there is a reflection that the provision as regards levying of taxes is provided under section 79F of the Assam Municipal Act. Now that contemplates publication. For any enhancement or levying, there has to be publication. Now, publication is defined under section 79 of the Act. Now, that has to be by way of publication in newspapers having wide circulation, one in English, one in vernacular. Now, the query in the order dated 4/11/2025 were twofold. One was upon the municipality as to whether there was, apart from the mode in which they published the notice of hanging it in the office board and allowing 7 days, allowing the public to have objection within 7 days, was there any publication within the meaning of section 79 that was carried out? Well, as of now, in my understanding, there is no such publication. That is something that has not fallen from the municipal. And so far as the query put before the Director of Municipal Administration was concerned, that was to the extent as to whether there is any other mode of levying taxes apart from the provisions under section 68 and section 148, which the answer is no. But at the same time, in the affidavit filed by the Director of Municipal Administration, they have, my lord, in one of the subsequent paragraphs of their affidavit stated that the hanging of the notice in the office board of the municipal office can be construed to be a notice. Now, to that, I have, my lord, filed my reply. I have responded to it. I have opposed to this text, saying that this is not bound by any notification nor any rules, and not, least to speak, the provision under the statute. So they are trying to justify the action of the executive officer, the then executive officer of the erstwhile municipal court by saying that the notice that was hung, the notice containing the budgeting notification that was hung, that can be construed to be a notice. Your lordship will kindly see their paragraph. My lord will kindly take up their paragraph number 4 at page 197. And this I have confronted by way of my reply, in which I have elaborated that this is not born out of the statutory provisions.
Yes, Madam Yuda. You see, there is no quarrel with the proposition that you can, the municipal body can impose tax on the society. There's no quarrel with that. But how do you determine the rate?
Wait. That silent on.
No, the municipal act is very clear. Kindly see 79.
That is after Malad
No. Kindly come to 79.
29.
Yes. 79 therefore relating to tax. It's not a tax. It's a betterment.
Termination of tax.
What is that? This is the fee. This is the betterment. It's a betterment fee is under what? Rule? It's a
8.
Huh? 68.
We have quoted Malad.
1K, a betterment fee on holdings in any area which value has increased due to improvements in completed at the board's cost. So that is why so the value has increased due to improvement schemes completed at board's cost. So here the cost has been imposed by whom? Who has incurred the cost? Water, it's not a water tax. The betterment is the tax rate. Park tax is taken. Now let us see that notification by which you have increased. Let's see.
Page 119. No, increase means the budgetary provision.
Now where they have stated that it has increased.
Page 119, this is the affidavit in opposition filed by the Cincinnati Municipal Court.
Now where is the imposition of the betterment fee?
No, there is nothing as such. This is only the budgetary provision which incorporates, which includes not only water tax, which my senior is saying, that includes as many as 265 other taxes. That is also under challenge in the application.
Where?
This budgetary provision, my lord, this is in regard to this is at page 119. And the approval that they have got is at page 121.
What do you
along with-
say? Yeah, let us see.
The approval is 121,
Approval is 121 along with which,
123.
for 123, along with which they have enclosed the various taxes which were the expenses and the statements of income and expenditure.
Where do we find, Mr. Doctor, where is the betterment fee?
My lord, your lordship, can you see the affidavit filed by us, page 163. The lordship may kindly come to page 178. One 178. The column number 105, in the middle, your lordship will find betterment fee at the rate of rupees 300. This is step rate charges.
Where the betterment fee?
It's written there, my lord, your lordship, at page 178, your lordship will find.
With one
Betterment fee,
78.
yes, head of receipts, in that column, your lordship will find. Your lordship, can you see head of receipts, then road damage repairing charges, then rebate from state government, then auditorium, then betterment fee.
So this is the betterment fee.
Well,
At a rupees 300 per month,
per month,
per temp.
per temp.
So this is the betterment fee. Yes. So it's not the tax.
This is not a tax. It is enhanced from 125 to 300 at a go. And along with it, the other taxes which have been enhanced, that we have assailed, that your lordship will find at paragraph 7, page number 13 of my petition, to which there is no response till now.
13.
Page number 13, paragraph number 7 of my petition. From what rate to what rate the enhancement is there, we have come to know from the publication of an article in one of the local daily.
In order to appreciate this, I'll take your lordship to page 125. Whether this enhancement is needed or not.
This is not a tax.
This water is not a tax, it's a betterment fee.
Others are also not tax.
Well, your lordship will kindly see out of those rates of tax clearance form.
How are you concerned, Mr. Consul? How are you concerned with the birth certificate? Anybody died?
My lord, is that the enhancement?
In the
That-
top of everything, your lordship, kindly see. Some persons has come here and all these people, taxpayers are paying the same rate. They have been.
But at the same time, Mr. Dutta, one has also to appreciate somebody has to come.
But then whether they are representing the whole mass, that's the
May not
question.
be. They may not be representing the whole bunch, but they may be agreed if they are affected. That is why my question to him. Has anybody died out of birth and death?
But these are the persons, they are having some political agenda. For that, they want to expose themselves.
Political, nowadays, because of political agenda, you have many cases.
That's true.
Then help it.
That's another aspect, my lord, the profession, we were not closer yet. But then
So the only tax, but Mr. Chakraborty, at paragraph number 7,
My-
all these not a tax.
my lord, these are forms. These are forms.
These are not tax.
My lord, these are not taxes as such.
This is a form of they have enhanced what is it? The mutation form has been enhanced from 250 to 400.
My,
All these things, they are increasing the rate, the rate of which the services are being provided. So this is nothing to do with tax. No, so as regards the water which has been increased from, it is not a water tax, it is actually a betterment fee,
my lord,
which was initially rupees 125, it has been now made 300.
my lord.
So that is how it comes to. Then what is wrong with it?
And my lord, in so far as this enhancement of license forms and all these things are concerned. Now, these, my lord, so far these enhancements are concerned, those were also done, my lord, in contravention of the provisions of section 68, which provides for license fees and, my lord, in so far as the other fees are concerned. Now, these fees,
Now,
For
if you are
any-
raising those issues,
my lord,
then you have to go there,
No, I understand, my lord.
division bench, as a PI.
My lord, here, my lord, as petitioners, as petitioners,
No, you had a case of water tax, it was a water tax, but it is a betterment fee, which they have put in. You can only go on the question of betterment fee.
my lord.
Now, the betterment fee is another aspect that it has to be on the basis of expenditure incurred by from the cost of the own board.
Quid pro quo.
No, if there is a expenditure incurred on the board, but if it is a grant given by the state, would it come within it? Look into that.
My lord, that aspect also, my lord,
It is there. I need not, one morning today I have been giving advice. I need not give you any further advice. So this is the thing you need to look into it, because if I remember this matter, they say that we are imposing this thing on account of that we are providing better things now. But on account of infusion of funds by the state, if that is being for, then how can there be a betterment fee if it is not spent from the state, from the coffers of the municipal board? Come up with that.
my lord, yes, but my lord, one aspect, if your lordship allows me to. So far, the betterment fees is concerned, that is also within the ambit of section 68 of the municipal act. Now, so far section 68 is concerned, that is the only provision which speaks about levy. And in so far as the rates on which the levy are to.
You meant to argue that if levying is one thing, but increasing is another.
Well, increasing, my lord, 79F is there, but then my lord, argument that comes.
So if there is nothing, that means how are you having the increase?
That is what.
Miss Yudas, how is it possible? You see, everything has to be a procedure, isn't it? Isn't Article 21 says that no person shall be deprived of his life or liberty without the procedure established by law? Where's the procedure? Are you saying that 68, you have a power to levy, but without a procedure? For tax, we understand there is a procedure given in 79A to F. But where is the procedure for betterment fee? You don't have a rule made. Therefore, my question was, did you make the rule in terms of 302 X? Well, I'm asking, I still remember one judgment passed by this court. What happened in 1993, you had the Assam General Sales Tax. Then they did not make the rule. The power to impose is there by the act, but you don't have the rule for deduction. It says that if any person is to be paid, there will be deduction of tax at source. But to deduct, what is the procedure? The rules were made only in the year 1995. So therefore, this court held that unless you make the rules for that, you cannot. The 68 is the power. But where is the power? How do you do it? Wouldn't it be violation of Article 21? So it will be done all hidden inside you. You can put a notice in the board, that is enough. Nobody will know anything. Public won't know. So how do you take care of it? Anyway, we will hear this matter and then dispose it off. Tuesday, Thursday. Now all pleadings are complete.
Now all pleadings are.
You are see find an answer to that. How do you take care of that? In that regard, possibly the rule has to be framed. The rule has to be framed. Now the question is, something has to be done. If you don't do it, we will be constrained to interfere. The act has been there for the last 75 years. More than 80 years.
Yes.
80 years and you don't have the rules. Your situation is similar to that of in your system. Your situation is something that of the Gauhati High Court who doesn't have rules. There. Okay. The pleadings are complete and as such, it is the opinion of this court that a petition requires to be heard and be heard expeditiously. In as much as there is no interim orders passed. List the matter on 25th of 28th of May 2026 at 2 p.m. for final disposal.
Thank you.
God bless.
Well, this is non-payment of contract was been last time, so it's the Gogo is taking time on behalf of the central government to clarify some point, man.
I am making. My lord, the last occasion, my lord, I could not appear, but he go away. My lord, I am paying for some time to take instruction.
Who is to pay?
Paid by the government, my government of Assam, my lord, but central government is a scheme sponsored by the central government.
Scheme of the central government.
Central government, my lord, that is under MPR. So, State of Assam said, my lord, state government said that, my lord, that contract which I have done, that is not fall under that scheme. But I have pointed out that it is very much in the scheme. My lord. That's why my opinion of the central government was required. My lord.
And the central government is not doing it.
They have last
69,
last occasion they have taken time.
69 of the. Page 16, annex 5.
Mr. Doctor, now the thing is, people keep on changing. Today you are appearing, then the other day Mr. Taylor you are appearing. And because of your changing hands of the particular of this brief, this court is there is a delay in disposal.
My lord, handover was made, but
Are you
was
going to
in a order.
We are only asking for an instruction on that aspect. Why you are not filing it? These are matters of the year 2024.
Yes, my lord. Page 69, my lord, it is page 69 of the my of the read petition.
Which petition?
Last pyramid. It is related to Commissioner PNRD Assam by Deputy Commissioner DPC MDNRE. Last pyramid. First, in response to the letter, we have received a reply from the PNRD Assam by return number mentioned under reference to serial number 2 regarding the implementation of flood control work under MD NREGA. After receiving the letter, the executive engineer DRD Dubli has accorded technical solution of approximate and such and such numbers scheme of erosion protection work and according to the same work accorded administrative approval by the then deputy commissioner. Out of this 1287 numbers scheme, approximately 800 to 85, 850 numbers scheme was stated and now nearing completion. But sure, in the meantime, we are in receipt of the notification dated 9th November 2021 mentioned under reference at serial number 3 regarding the suspension of the executive engineer Jila Parishad Dubri, who is also the
I see.
Where is the PNRD? When a matter is being taken up, Mr. A.K. Dutta appearing on behalf of the central government
Yes, my lord. As per number.
admits that he has no instructions in the matter in spite of a specific order passed by this court on
My lord, 2023, 2003.
20. No, not that.
He's your 31.
On 31,
No, my lord,
Another one,
But-
yeah.
thereafter, my lord, it is from to RT, PNR.
I passed them for order once.
23, 2000, last occasion, my.
On 31, 2026.
31 mile to PNR.
Again on 20 March, 20 March.
None appears on behalf of the PNRD on call. Or has placed any instruction in terms with the order dated 10/11/2025. When? 27/3. What is your saying? These are all affidavit in reply. Where is your affidavit? Don't have any. We have two affidavit in replies. I'll be response number 3. Where's the affidavit? There's no affidavit here. One affidavit you have filed there.
One affidavit in 4736/2000.
What do you say?
It's a non-permissible work, Lordship. In our stand, it says it's a non-permissible work. So, Lordship,
Then who granted the work to them?
Lordship, it's a central government scheme. So, central government scheme. So, Lordship, central,
Where's your affidavit?
one affidavit is from the central government. Then
Where?
in earlier date also, the central government was take time to file affidavit. Please.
Understood. I've understood that, Mr. Counsel. My question is, this is of 14th of August 2025. Your affidavit. When?
2026.
Page 157.
Page?
In item 26, that's it, item 26.
Now, The question is, who awarded the contracts to these petitioners?
Lordship, actually, it's a, in district level, it's a DPC is the main person. DPC.
Huh? Who?
DPC.
DPC?
DPC.
What is the DPC?
DPC is the main person, district development.
He is under which department?
PNRD, but
So it is you who have issued the work order.
work order was issued by the district commissioner.
Let's see one of your work orders. Let's come to Uttam Kumar Saha.
Yes.
Where is the work order?
Page 45, my lord.
Who has signed it?
Secretary Gaon Panchayat.
Muthua Gaon Panchayat. Who is the secretary of Muthua Gaon Panchayat?
It's under PNRD.
Huh?
Under PNRD.
No, if he is under the PNRD, if you have issued this work order, you have to pay. How are we concerned with anybody else? How did you issue the work order? Was there tender?
No, that's it. We
Huh?
That's it. We have already filed our affidavit. We clearly said that there was, no tender was issued that time.
And in pursuance to this, the petitioner supplied.
Yes.
Lordship, we have already clearly said that in our affidavit, candidacy page number 159, paragraph 5. 159. In our affidavit, paragraph 5. In item number 26, Uttam Kumar Saha. No tendering or quotation system was placed at the time of allotment of works, and works were allotted directly to the fund.
Now, if the works were directly allotted, how will the people get the money?
So Lordship, it's a central government scheme. If central government clarify that it's permissible work, then we will pay.
No. First of all, on one hand, let's assume that the central government says, yes, it is a permissible work. But how can the petitioner get a single penny when you have issued work orders without even a tender? Without calling for the rates? I think we should give a CID inquiry. CID inquiry. Now the secretary of Muthua Gaon Panchayat, does he have the power to issue such work orders? Without tender?
As per our instruction.
Possible?
Yes, my lord, it is as per the scheme, my lord, it is, my lord, what happened here in this case, my lord, the flat relief, my lord, flat.
No, that or whatever may be, they have to have a petition.
The porcupine work is not the permissible work.
You are saying about this work order, you are saying about flood relief. No, let me tell you. You are saying about the flood relief. Kindly come to page 45, which is your work order.
My lord.
How there is flood on 12th of February 2021? Huh?
No, that, my lord, your.
Then, this type of, I think we should.
No, I lord, your lordship
with
kindly, no, your lordship kindly, my lord, buildings are completed, I'll argue and your lordship kindly fix it. Yes, my lord,
Not satisfied because of the fact that if there was no tender, this
No,
would
my
be-
lord,
you
that
will
is not the issue.
go before the civil court, go
They have
while On quantum merit, section
No, no, that is-
17,
that is
not
not
this,
the issue here, man.
not this court.
That is not the issue. Nowadays, say that it is not under a scheme, my lord, because
Forget about the scheme or no scheme. If it is under the scheme also, is it permissible with to grant it without a tender?
my lord, they have already supply work has been, we have to
So how
supply.
can there be a supply work issue?
And my lord, they
Just
have
for
also.
example,
some
my
amount of money.
question is, these supply works which have been, these are supply works which have been
They are, my
issued.
lord, you know, kindly fix it, that your hearing, I'll go on that point, my lord, because now says only.
Yeah,
Porcupine
we are
part-
not concerned with 10,000, 20,000, 10 lakhs, 20 lakhs. We are concerned with 3 crores, 59 lakhs without tender. How is it possible? And who is going to look into all these things? The name of the work, Uttam Saha. Each of the pending bills are 9 lakh 49. And why? Different works, all these things, every work has the bill of 9 lakh 46,149.
My lord, your lordship kindly, there is a.
Not
confusion, my lord.
satisfied.
No, your lordship kindly.
No,
fix it,
lordship,
my
no
lord.
tender.
No, that's why, my lord, they say that it is no. What?
Don't find any affidavit, will not satisfy me.
Last time, last occasion, that's why, my lord, now already half of the amount, only Porcupine part, what is not been paid.
Porcupine, you can't get it, and Porcupine is outside the scope.
No, my lord, that is the
And
case, my lord.
first of all, if you have given it,
No, that is the
take
case,
the
my
money
lord.
back.
It is within the scheme, man. Porcupine is within the scheme. So your
no,
lordship kindly fix it,
without
that-
tender, how is it possible? Let us write it down. Urge
Ah.
Mr. T.J. Mohanto, the learned senior counsel, assisted by Mr. M.R. Pandaka, the learned counsel for the petition. Ms. N. Gorai appears on behalf of the PNRD department. Mr. A.K. Dutta appears on behalf of the CTSU. Ms. Udas appears for the additional senior government advocate, appears for respondent number for the district administration. The present batch of petitions have been filed claiming certain amounts from the respondent authorities on account of certain works completed by the petitioners. This court have duly perused the affidavit in opposition filed by the PNRD department, which have been filed in WPC number 4736 of 2024, wherein it has been categorically mentioned that these tenders, these work orders which have been issued by the secretaries of the respective Gram Panchayats have been issued without calling for any tender or without fixing the rates prior to the issuance of the work orders. It is also mentioned out there that some of the schemes on which the petitioner makes claim is not within the MNREGA. Mr. T.J. Mohanto, the learned senior counsel appearing on behalf of the petitioner, submits that he would satisfy this court that on the basis of these work orders, appropriate directions can be passed upon the respondent authorities for making due payment. Taking into account the above, as the pleadings have been filed, it's the matter on 10th of August 2026.
Maybe earlier than that. Maybe earlier than that.
Earlier, I am going to hold the bench for and discuss your petition. So,
My lord, after hearing me, you are not to be allowed.
No, this is an IA file. By implemented respondents, my lord, 4 and 5.
what is your case?
Actually, what has happened, my lord, the certificate was issued by the proceeding before the RERA, and following which lucky their proceedings were instituted, and ultimately there also, my lord, orders were passed. But then the authorities, I mean, that is the allegation of the writ petitioners in the writ petition, that having delayed the matter, they filed the writ petition to expedite the matter. There's an award, my lord, of 46 and odd lakhs against the applicants, my lord.
Who filed the writ petition? You filed the writ petition?
Yes, your lordship.
Now, what was the writ petition for?
Your Lordship, first of all, there was an agreement in the year 2013. I entered into an agreement with the builder that they, within the period of 36 months, they'll hand over me the flat. Accordingly, money was paid. More than 95% money was paid. Till 2021, they don't hand over me the flat. I go before the RERA. RERA passes an order saying that within 45 days you complete it and hand over, or else you pay the money. They did nothing. Thereafter, in 23 again, I went before 22 again, I went before the RERA for executing this case. Therein, I filed the executing petition wherein the RERA has directed that 27 lakhs plus interest that amounts to 46 something that has to be paid. Accordingly, Bakijaya proceeding was initiated in 23 itself, and a notice was served upon the builder. She appeared and she said that I'll pay the money within 3 months. 3 months lapsed. Then thereafter, again by December, that also lapsed. Then she deposited 2 post-dated checks. Those also got dishonored. All things are on record, Your Lordship, in the writ petition. Thereafter, I approached this honorable court for initiating the Bakijaya proceeding, which was not being initiated.
Bakijaya proceedings have already been initiated.
Yes, Your Lordship. But that was not taken to its logical conclusion. Then thereafter, the respondents appeared and said that they will proceed accordingly. Thereafter, the builder again came up before this honorable court and said that that needs to be stayed.
Which one?
The Bakijaya proceedings. Accordingly, the court directed in the interim that, okay, fine, the Bakijaya proceeding will not continue. Your properties will not be sealed. In the interim, you need to deposit 20 lakhs.
Within a period of 10.
They agreed to that. That was a consent order. That was, although I was not served with a copy in that at that moment of time, they didn't pay that money also. And there is apparently a finding and observation of this honorable court in that case.
No, but one thing, you have approached this court for the purpose of continuation of the Bakijaya proceedings or the Bakijaya proceedings being brought to a logical conclusion.
Right, Your Lordship.
That is the reason why you have approached.
Right, Your Lordship.
We are not here to look into anything, but it would be amounting to challenging the order of the RERA authority, which an appeal lies to the RERA appellate authority.
Right, Your Lordship.
So they have to challenge it before the RERA authority, appellate authority as regards the RERA.
Correct, Your Lordship.
Now, there is nothing wrong as regards the Bakijaya proceedings.
Correct, Your Lordship.
Only thing is that the Bakijaya proceedings was not proceeding.
Right, Your Lordship.
Now, when there is a requirement by the Bakijaya officer, by the RERA authority asking the Bakijaya to proceed, which is permissible as per the RERA Act,
Correct, Your Lordship.
and the Bakijaya proceedings is being not proceeded with, you have approached this. Now, if it is being proceeded with, and has the property been attached?
Property has been sealed yesterday, and therefore they are before this honorable.
This
Not necessary. You have given undertakings, we dismiss it,
no.
and the property be sold.
Your Lordship.
Let the property be sold. We pass that order.
Madam,
No. You cannot take these people for a ride.
proceed kindly, my lord, consider this thing, my lord.
No, sorry.
My lord, none of
Pay
the
that
orders.
47 pay that 47 lakhs
No,
within
20
3
lakhs, I'm ready with this draft is.
How much?
20 lakhs.
No,
I have
20 lakhs.
reported 26, my lord, I need some time.
26,
That, your
nothing,
lordship will guide us.
nothing doing.
Reasonable.
Why should we go into this 26 or the direction is to pay 47 lakhs? 47 Bakijaya proceedings is the manner in which the amount would be taken out from you. It is the duty of the Bakijaya officer to do it.
Need to pay, and this 20 lakhs, my lord, it is with me, my lord, I can hand over, your lordship may record man and some, give us some time, my lord, I will pay that.
7 days? 7 days?
3 months.
No.
My lord,
No. Mercy,
my lord, 3 months.
Page 111 is
Let
the
me
order
not
of.
fail it, my lord, let me not fail it once again.
I can give you 3 months provided Mr. B.D. Goswami by yourself, you give an undertaking, otherwise your property would be at stake. Give it. Give that. No, I am telling you that because you also don't trust your own client. Can you give that undertaking? No, Mr. Goswami, don't come up with this type of merely because of a client have engaged you, don't come up with this. You give an undertaking. Otherwise, your property would be at stake. Then obviously, I will say, okay, I will go, Mr. Sinha would also not say anything, that remaining amount, if it is not paid, kindly take over my property. Give it.
Page one
Come
one one.
up, this is a matter of 2013 till 2021, we are in 2026. You have made the RERA Act a fool of itself. Sorry.
My lord, there were problems, but now we are not getting into since certificate was issued and my lord, Takide proceedings. were-
Understood. You know about the fact that you are going required to pay on 47 lakhs. It is not that you are not, you appeared, you have agreed to earlier also. Now today coming after all this while and coming to pay with this thing. I'll give you 3 months, but provided you give me that undertaking, can you give that? Mr. Goswami, can you give that undertaking?
My lord, on the last occasion when my mother expired, that he should be aware, my lord. The last occasion, my lord, when the order was issued, my lord, the very day, 30th of April, my lord, my mother expired. All these things are going on, but in spite of that, my lord, I have agreed to pay this 20 lakhs. my
No,
lord.
no, you are not to agree. You are bound to pay.
I'm bound to pay, my lord.
This is not a question of agreeing. You paid, okay, we give this 20 lakhs to him, but within 7 days you pay the remaining.
Some more time, some more time.
14 days.
Some.
14 days.
But 2
After
months,
14 days, we'll again.
Page one 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 is the order which
My
makes
lord,
very
may I
clear
take
how
a-
they played with the orders of this court.
My lord,
That is more painful.
instructions you lost for time.
We will stay it subject to paying the 14 days.
My lord, you lost for time.
And also file it by tomorrow. Your your details of your bank accounts, all properties which are there, provided. Yeah. No, that is what we will seal everything otherwise if you don't pay. Done. Warrant of attachment. It is only an attachment.
And they have also, my lord, not my lord, paid the money and the price in full.
No, it is only an attachment, not seal. It is only an attachment.
27 for my lord, then.
No, let the attachment continue.
IMM.
Now, what happens? Once it is attached, thereupon it will be put to sale. There shall not be a sale. Attachment is okay. You cannot transfer.
My children are in school, but their books are inside, my lord.
Attachment is not sealing.
My lord, they have locked it up.
No.
They have locked it up. I'm in a homestay, my lord, near a homestay. That is what is done. Your lordship will kindly come page 15, my lord, annexure C. And that was in notice. No time was given by the same day they had seen it.
You know about this thing. Yes, what do you say? Instruction.
Well, 13 days, your lordship can.
You do one thing. 20 lakhs you give it now. Remaining 14 days, next 14 days, you pay. How much remains? 46 lakhs.
27 lakhs.
46 lakhs. You pay 17 lakhs within 14 days. And then remaining another 14. 30 days. You only say 30 days. Didn't you say 30 days? No, didn't you say 30 days? I'm giving you 30 days. First 14 days, next 14 days, you pay 17 lakhs. And the remaining 10 lakhs. 10 lakhs, na?
Yes.
Another 14.
10 lakhs first, my lord. 17
No,
lakhs in
10
fact.
lakhs, no.
But first
No,
10 lakhs.
wait, Mr. Remaining 10 lakhs plus other execution expenses is also there.
This money is supposed to be paid in 23. We are in 26.
My lord, my instruction is that we are planning to, my lord, hand over possession of the flat by 31st of July.
That is
Full and
to whom?
to him.
You see, the amount which he has been directed for you to pay is the amount which is the consideration he has paid to you. And along with that,
Yes, but very
along
high,
with interest,
very high.
no, very good. This is, I think, how much? Have they put it 18%?
No, 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 much lesser than that.
How much? Is it 18%?
No, your lordship.
It is 27 lakhs.
And remaining?
And
Your lordship, they have paid me 27 lakhs, 28,000 is the principal amount. And 19 lakhs, 4,835 was the interest amount.
From?
This interest was from 2013 and it was awarded on 25/10/2013 for a period of 10 years.
10 years. With 8%, it becomes double.
I think it was something less
It
than
is level
8%.
6. We make it 18%. We increase it. Don't come up with this type of excuses. We do one thing. You pay this 20 lakhs. Next 14 days, I'm fixing it on 14 days. Prior to that, on that date, you bring the check of 17 lakhs. Then on that day, we will enhance again the stay order to the next date after another 14 days or 16 days.
just pay.
Then no,
No check, your lordship, draft.
It will be 10 and 17. That is all.
no, not 10 hours.
10 and 17. That will slightly make things easier for me.
Okay, then 15 and 12. 15 and 12.
Take no demand draft.
Is there demand draft, no? The demand draft has been enclosed to the petition or application also.
Yeah, but that is a copy, man. This is the Excel one in my.
ICICI Bank, Joy, it is signed by ICICI on 27/3. What is the date? 28/4/2026, no?
28
Today he has made it. Yesterday.
yesterday.
To file this I.
27/4, my lord, they sit my property.
So then you woke up.
I didn't wake up, my lord, but
You means always were awake. Okay, heard Mr. B.D. Goswami, the learned counsel appearing on behalf of the applicant, who is the respondent number
4 and 5, but
4 and 5.
application is by my lord.
Petition.
4 and 5.
The instant application has been filed seeking stay of the order dated 27/4/2026. Passed by the Circle Officer, Dispute Revenue Circle, as well as the issuance of warrant of attachment of immovable property dated 27/4/2026, issued by the Additional District Commissioner cum Certificate Officer, Kamrup Metro. Mr. B.D. Goswami, the learned counsel appearing on behalf of the applicant, submits that out of the total amount payable, that is rupees 46,32,835. And other incidentals which are to be paid on account of the execution of the proceedings. The petitioner, the applicant is today handing over a draft, a demand draft in the name of the petitioner.
Number 2.
Number 2
We need a mark vote, my lord.
of the petitioners. Now, how can the demand draft, you have a joint account?
I'm not sure. I need to take an instruction for that. I have to take an instruction. Your lordship, give me 2 minutes.
The name of the petitioners. And the remaining amount of 26 lakhs 32,835, along with other incidentals, would be paid before the instant court, before the court, by way of separate demand drafts within a period of 30 days. Taking into account the said submission made by the learned counsel appearing on behalf of the petitioner, applicant, to be an undertaking before this court. This court stays the warrant of attachment of immovable property dated 27/4/2026, issued by the Additional District Commissioner cum Certified Officer Kamrup Metro, as well as the notice dated 27/4/2026, issued by the Circle Officer Dispur Revenue Circle, till the next date. Pusto.
They've seen the house. They've seen the house following this order.
I've stayed it, na?
But
The moment it is
unless they
stayed,
open the seal, I cannot return my finger.
Your lordship, I've just taken the instruction, they don't have a joint account. He has either to be in the name of Madhurya Bhattacharya or Vinita Sharma.
By tomorrow.
Then let this matter be tomorrow in that case, your lordship. And let them, tomorrow at 2 p.m.
Tomorrow at 2 p.m.
tomorrow at 2.
First applicant.
Our paragraph within 30 days. Within 30 days, he can liquidate. The learned counsel appearing on behalf of the applicant submitted that the petitioner is ready to deposit hand over the demand draft to the counsel appearing on behalf of the petitioners during the course of the day. Upon perusal of the demand draft, which have been enclosed, a copy of which have been enclosed as Annexure E to the writ petition, it is seen that the said demand draft is drawn in the name of both the petitioners, and it is submitted by Mr. R. Sinha, the learned counsel appearing on behalf of the writ petitioners, that the demand draft, if paid in the name of one of the petitioners, would suffice, inasmuch as both the petitioners do not maintain a joint account. Mr. B. Goswami, the learned counsel, B.D. Goswami, the learned counsel appearing on behalf of the applicant, submits that such demand draft shall be prepared and produced and placed before this court tomorrow. List the matter tomorrow at 2 p.m. No stay now.
Keep the obliged.
I know that Deputy Commissioner was asked to submit some documents regarding the matter. It was written to the Deputy Commissioner on 12/11/2025.
Affidavit filed by respondent number 5. Who is respondent number 5?
DC law.
Who is to pay?
Revenue Department.
Why is revenue not a party?
Malad, it is not a party on earlier occasion, Malad. It was made party on 25/6/2025.
They have made a party. Who appears for the revenue now?
What's the I don't.
And who appears for the respondent number 5? Now, what do you want? Do you want instruction?
Malad, that some documents we are seeking from the Malad Deputy Commissioner.
That was not been furnished to us.
What documents you have?
All of that regarding
You
the
must have written a letter to the deputy commissioner.
already been written.
What is the number of the letter?
What's it called?
No. This is a very vague letter. You are not taking the matter seriously. The record reveals that on 18/3/2026, the Standing Council of the Revenue Department sought for 3 weeks time to obtain instructions and file counter affidavit. No affidavit has been filed by respondent number 6. Thereafter, list this matter again on 22nd of May 2026. In the meantime, a final opportunity is granted to the respondent number 6 to file the affidavit on or before 18th of May 2026. It is observed that if no affidavit is filed, that the same would amount to delaying the disposal of the instant petition, and accordingly, this court would be constrained to seek the personal appearance of the concerned officer of the Revenue and Disaster Management Department of the Government of Assam to answer the contents and allegations of the petition.
So I may take a small point on 1/12/2025, Your Honor, sir, that passed a similar kind of order where it was stated that in case they didn't file anything, the matter will be pursued as it is. Thereafter, they took 2 subsequent dates and till date they haven't filed any affidavit.
This is the matter for further hearing on the next date, taking into account that the matter has been substantially heard.
Keep your post.
Will recall that is that issue concerning the management of the society in Canada. The Lord will recollect initially a writ petition was moved, and it came from the bench that perhaps he'll have to file a review against the earlier order which had closed out the proceeding. And that is how Lord we filed a review. The review is before your Lordship. Lord, just to recapitulate, and just point out what had happened.
I remember there was a case where a suit was filed by one member as regards some allegations in the year as regards the control of the Gymkhana Club.
That's right.
Some order was passed.
Some order was passed and
Against that, a repeal was filed or revision was filed beside this court. This court passed such an order by appointing one senior counsel out here as to hold the election. Thereby, the entire effect of the suit was nullified in the proceedings under Article 227 of the Constitution. Now, that particular person who was directed to conduct the election has said that it is impossible to do so. But the repetition was disposed, the revision was disposed of, and as such, nothing could be done. This has led to this proceeding. In the meantime, you have now somebody who was Mr. M.K. Chaudhary was there.
Before that, I filed an application under 151 requesting the court to at least give a time frame within which the exercise was to be completed.
I say I closed it on the ground that in a disposed of matter, how can you file that application? Then in the meantime, Mr. M.K. Chaudhary was the counsel who was appearing in the petition, assisted by Mr. P. Mohanto, whose father is the review petitioner.
Yes.
He filed an application stating that he is making the society a party, society breaks, these people are party and filing a suit, the petition. this repetition is of no consequence, it's only to be dismissed. So the only thing is whether this court should recall the order they take. I order and then apply 151 and recall the earlier order, taking into account the judge who passed the earlier there, it has already demitted office. That's it.
We just want the elections to happen, you know, it's in a state of uncertainty, you know, whoever wins is not the concern. But
Mr. Chaudhary, let us first dismiss your petition, come to this side. Therefore, let us first dismiss your petition. Let me give some relief to Madam Adorita, who has been waiting till 4:30 every day for this matter.
Lord, I am before your worship, my lord, to see this organization. It's a reputed organization, your worship. And before your worship, my lord, no election has been held for a very long time. But the only prayer that I am making that, my lord, let the election be in whatever terms, my lord, or whoever conducts it, let the election be held, my lord, then my lord, let the that is the reason why I am.
Now the election, why can't it be held?
My lord, what happened? Earlier, my lord, there was a suit that should have been, my lord, disposed of, and your worship must have seen your worship earlier order.
No, the problem arose because of that order, the revision order, whereby it passed such an order that it had the effect of nullifying the entire suit. Isn't it? And thereby appointing a particular person, the commissioner, to hold the election. And that commissioner came up and said that we can't hold the election.
For the holding of election, that might not be having the malfunctioning or might not be the management of the council, all of that.
We do one thing. We allow his review application, thereby recall my order passed in 151 application. Then we revoke the 151. I think the only.
There's a problem here also.
There's no problem.
The society, yes, doctor. The society has not the restriction.
Madam, I'm not on that petition. I'm not on the petition. My question is, in the review petition, an application was filed under 151 in that matter, in the main case. I rejected the application under 151 on the basis that in a dispose of matter, an application, in this case, cannot be decided. That order appears to be wrong, taking into account that application is an application for recalling that order. So therefore, it is not an application per se, an application seeking any directions on the basis of that order. So therefore, that 151 application can be an application for recalling, taking into account if there is a mistake committed by the court. If we see by the judgment of 1994, 1994 SSC, that Good Singh or that judgment. So therefore, my order which was passed for dismissing the application is wrong. So therefore, this review application, I allow it and put and recall and restore that application. Then the 151 I'll look into. The petition will dismiss. The suit has to be completed.
The suit is already completed.
Therefore, the question is, if the suit has come to an end, that petition 227 has become bad. Now, suit had come to an end on for what reason?
For being infracted.
Because of the order which has been passed by us. Now, if I interfere under 151 to that application, that order, he can very well revive the suit under again 151. That order. He will, he can revive. But you don't want to proceed with that, then the suit has become closed. But this order would not remain. Then if you want, it is your duty. Then the suit would get dismissed or whatever may be. Then there is no suit.
From the ground and person has been appointed to conduct it.
Understood. So therefore, this is because of the order passed by this court. Now, if I recall that order or modify that order and in application under 151 filed by them, then in that regard, you would be also required to revive that. If you don't revive that suit, you are at doldrums.
A reputation that becomes liability will be dismissed only in the event your lawsuit allows the review petition.
I'm allowing the review petition just now. Madam Hazarika, the only way is to bring some action in the proceedings. You can't have a status quo. If this status quo continues to remain in the manner in which it is being done, then it will have an impact. It is, after all, an institution, whatever may be. Whoever controls it is a different thing. Whoever wins the election, whoever does not win the election, I'm not concerned to that effect. But that institution cannot be put in a status quo like this because of a mistake committed by us. Without any thing, I can very well say, although my order which was passed closing may not be so egregious, but the order which was passed by the coordinate branch was egregious in the 227 proceedings. What do you say, Mr. From? Yes, the organization has to be there. Because of vested interest, the organization cannot be. Anyways, let's allow the review petition.
There's
my
there's
order.
one more problem. Not what about the fact that the club list is not a, as on today, the club is unregistered.
It's okay. We'll look into it just now. But let me recall
Which
my order.
expires in 2015.
Where's my order? 840. Heard Mr. B.D. Das, B.D. Deka, the learned counsel, appearing on behalf of the petitioner, review petitioner. Ms. M. Hazarika appears on behalf of the respondent. Number. Who are the respondents you are appearing, Mr. Hazarika?
Yes.
1, 2, 3, 4.
1, 2, 3, 4. 1, 2, 3, doctor.
Huh?
1, 2, 3.
1, 2, 3. What about 4?
Four, personally. Yeah, 4, 4, 4.
1, 2, 4.
4, only 4, doctor.
Yeah, 4.
4.
You appear for 5, Miss. Who appears for Gurukana? You appear for 5. Mr. So-and-so, M.K. Chaudhary, the learned senior counsel, assisted by so-and-so, appears for respondent number 5. The instant review application has been filed by the applicant, seeking review of the order passed by this court on 4/3/2024, whereby the interlocutory application being, what is the number?
Oh, to IA 2362.
Being IA
62.
2362/2022 was rejected on the ground that the suit, on the ground that CRP IO number 244/2019 was disposed of by an order dated 27/8/2019. And thereupon, the title suit was disposed of by an order dated 11/1/2021 as infructuous in view of the order dated 27/8/2019 passed in CRP IO number 244/2019. Mr. B.D. Decker, the learned counsel, appearing on behalf of the review applicant, submitted that an error apparent on the face of the record had crept in the order dated 4/3/2024, by which the application filed by the review applicant was rejected, in as much as this court failed to take into consideration that the said application was an application filed under 151 of the Code of Civil Procedure 1908. For recalling the order dated 27/8/2019, passed in CRP number 244/2019, in view of the steps taken by the commissioner who was appointed by this court, that the elections cannot be held. It is the opinion of this court that when the order application which was filed under section 151 of the Code of Civil Procedure 1908 was an application seeking recalling of an order dated 27/8/2019, passed in CRP number 244/2019. This court ought to have taken into consideration as to whether there was a mistake committed by court in the order dated 27/8/2019 as per the settled principles of law, rather than dismiss the said application on the ground that it has become redundant in view of the disposal of CRP number IO number 244/2019. Taking into account the above, it is the opinion of this court that there was an error apparent on the face of the record in the order dated 4/3/2024, by which the application being 2362/2022, being IS civil number 2362/2022, was dismissed. Accordingly, this court recalls the order dated 4/3/2024, passed in IA Civil 2362/2022. I need to recall the order in respect to this application only.
Or no, that is our limited.
No, only in this application,
Only this.
because the others are
This year,
dismissed. Huh?
Then this year, then perhaps in the 151 application, I can.
No, there I have to deal with it. So therefore, but here what the court dismisses all applications filed before this.
So
So-
only in respect of 2, 3
Recalls the order insofar as IS Civil number 2362/2022. The interlocutory application being IS Civil number 2362/2022 is restored back to the file of this court. List the matter, but review petition accordingly. And this court further directs the registry to register the review application, and the review application accordingly stands allowed. The registry is directed to register the said review application. Why build an IA? For delay.
For delay.
Okay. Delay we condone it. Is an application, I heard Miss So-and-so, Mr. So-and-so, the learned counsel appearing on behalf of the applicant, and Ms. M. Hazarika, who appears on behalf of the respondent numbers 1, 2, 3, 4, and Mr. M. Chaudhary, who appears on behalf of the respondent number 5. There is an application for condoning the delay of 692 days in filing the connected review petition. This note has duly perused the grounds and reasons which have been mentioned in the said review application. No objection, madam. And there being no objection on the part of the respondents, to the condoning of the delay. This court accordingly allows the instant application, thereby condoning the delay of so and so. The registry shall accordingly the instant interlocutory application being civil IA civil number 635/2026 stands allowed. The registry is directed to number the review petition. Register and number the review. I will call it to the review petition. So the one here. Main to the is the interlocutory application number. IA is come IA 2312 IA 2360 of 2022. This court would heard Mr. B.D. Dekha, the learned counsel, appearing on behalf of the applicant. Mrs. M. Hazorika, the learned senior counsel, assisted by Mr. A. Biswas, appears on behalf of the respondent numbers 1 to 4. Huh? Only 4. How many applicants are there? Like, where is the application? Who appears for this one? PK Chaudhary, you appear. Montu Bora?
They were represented.
Saurabh Mohanto, just now you appeared for Saurabh Mohanto.
These were responded to the number
Of the, but in the earlier application where they parties and where they not appearing for them. Who Rabba?
You see Rabha at that point of time, he was appearing in the water.
Take it a 1, 2, 3 here for a 90. Play up. Is an application heard Mr. B.D. Dekha, the learned counsel appearing on behalf of the applicant. Mr. You are appearing for respond number 4, no? Mr. Hazorika, the learned senior counsel, assisted by Mr. A. Biswas, appears for respond number 4. Mr. M. K. Chaudhary, assisted by Solanto, appears on behalf of the respondent number 5. This court shall hear the instant application on 21st of May 2026 at 2 p.m. The respondents are the respondents will be at liberty to find the
Of that.
Get hold of those person concerned who is there and ask to be here. Writ petition, leave the matter on so and so. Huh? We are not, but the moment I do it, recall that order I have already reviewed. The recalling, if I do it and bring it, then your petition will be dismissed.
In that IA, we had also take for modification of that earlier order, so that we can the order pass for
You ask for recalling, na?
Modification, clarification.
You see, in a dispose of matter, how can you ask for modification? You have to ask for recalling.
I will amend.
Which one? For filing suit. Not necessary. I recall that order. I won't recall. You can't pick and choose one and portion. We'll see when the matter is taken up. Because this order, we have to do something with that particular order because you see, you cannot stall a particular thing which has happened. In fact, there was one case where in all courts everywhere there were 8 or 9 that matter pertaining to that. Amen Bolwa or
I have that.
there was one problem. Every case you come because of one order was passed, and that was a wrong order which was passed, and everything got stopped. Means there was an injunction which was operating for 11 or 14 years. It was just going on, injunction, and nobody could file an appeal because the person is there. And here the person is, you cannot impede anybody until the probate proceedings is not done. And you know, Kolkata High Court with a probate proceeding, how long it is going to take. Huh? That goes on. Therefore, I had to recall that order under 150. Right. Yes. What is this?
Here I have received instruction, Lordship. This
Non-payment.
Lordship, she admitted due the
Admitted. Hello. You can exfoliate this. You follow by Tamsir Ali, na? Not. With Tamsir Ali.
In fact, in this case, already part payment has been made.
No, my order categorically mentions of that if any amount is paid during the pendency, the same would be set off. X for asking.
Similar Lordship, I have also.
That will exclude you.
Oblige.
Starts matter. We are filing additional affidavit, bringing in subsequent development. I have sought for instructions. Instruction I have received yesterday. I want to file a short affidavit on that. Subsequent development, we have filed an affidavit. I want to file a short affidavit on that.
Mr. Ekmora, appearing on behalf of the GMC, supports that on 10/3/2026, the petitioner had filed an additional affidavit bringing on record certain subsequent events. And the respondent, GMC, would like to reply to the same. List this matter again on 22nd of May 2026. In the meantime, the reply be filed on or before 18th of May 2026.
My lord, as a senior, the senior
Oh.
government, first time appearing.
So we appear, yeah. Heard
I
Mr.
express my gratitude.
Heard Mr. A.K. Bhuya, the learned senior counsel, assisted by so-and-so.
I express my gratitude.
Yes, Mr. Sahiwala, where is he? Oh, no, Mr. Sahiwala. List the matter on which that Mr. Sahiwala appearing on behalf shall apply the whether the in respect to the work so and so of the requested letters of acceptance were issued beyond the bid validity period. What is your instruction?
Bid validity was subsequently extended.
That? What case you have?
I mean, the only thing is that
Okay, that day I wanted to dismiss.
I understand that, but only thing is that the letter of acceptance.
What is it challenging? I forgot.
I was awarded 5 works. Out of the 3 were on the 3 were terminated, cancelled on the ground that I have not submitted the bid security.
on that ground.
On the ground that you did not?
I have not submitted after receipt of the letter of acceptance. I have not submitted the subsequent bank guarantee. That was my obligation. On that ground, they have terminated the rest rate. The balance though,
There were 5 contracts. And out of that, in 2
No, I am
contracts
going-
you are happy with. In respect to the other 3 contracts, now I remember, other 3 contracts, you did not accept, did not submit the additional security or something to the pay, the performance guarantee. And therefore, they have recovered certain amount from you.
the earnest money which I deposited during the bid has been forfeited.
Have been taken away. Now, the question out here is the tender was to be done sometime in the month of September. But you gave it in the month of February or March or April. And thereby the rainy season has come and it becomes difficult. So therefore you did not give that. And therefore you want the money back.
That is
That is the case.
that is one aspect. The second
So
aspect,
my therefore question was as to whether the bid will, was the tender being granted beyond the bid validity.
it has
Because
been
till the bid validity period, you have to accept. And that is why the instructions were there on that aspect. The bad case, we discuss it here. Okay? Go to the civil court if you
no,
have.
my lord, only thing is that
There's nothing. What do you say? Nothing.
I think,
Nothing.
because within 21
Those
days
means-
from the LOA, he has to give.
that is my lord, that is my lord, one aspect of the matter. The second aspect, my lord, it may just come to page 52. Because of this problem, my lord, I could page 52, my lord. Or my lord, page 54, editing, contents of it. If my lord takes up page 52, the first para it says that I need to submit such and such amount as security. The last para, you were requested to submit an updated construction methodology and revised proposal. Now, my lord, this is the mandatory criteria to be fulfilled by me along with payment of this money so that the contract can be executed. Now, my lord, since I was getting the work only in the month of March or April, that my lord, that was there in Kachar district, there was a heavy rainfall. Because of which, my lord, I was not in a position to undertake the revised construction methodology. Construction methodology.
Mr. Council, one contract was for 12 months, one contract was
No,
for
no, no,
18
no,
months, one contract was for 24 months.
No, my lord, this was.
Yes.
No, I am not on that.
No, 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 no.
I am
No,
not
no,
on the-
kindly come to, no, kindly come to page 30.
My lord, this is the completion period. I am not on that matter.
No, that cannot be a ground. You see, this is the term of the contract that if you don't submit this, then it will be cancelled and by the forfeiting that amount. This has to be a term of the contract. Where is that? Where is that information? This is the internal completion date for year. Where is it? It says that it will be recovered.
Terms and condition is not there.
As successfully have not furnished the requisite performance security after issuance of the remand or the remand, the security amount of 581 is therefore forfeited. Period of validity, documents, no offer of, where is that offer of security?
My lord, may kindly turn to the page number 5, my lord.
Huh?
Bottom, my lord, page number 31.
Close.
Plus 50. 50.1. Bottom page number 30.
3.1. Within 21 days of the letter of acceptance, the society shall furnish the payers and so that the failure to submit the agreement shall constitute surveyor for annulment of the contract and forfeiture of the security. May award the contract to offering the next most advantageous. So, rightly done, 50.2.
Yes, my lord, that is the one aspect. The second aspect, if my lord takes up 50.2, my 50.2, the second law.
It will be given to the next one.
No. Failure of the successful bidder to submit the aforementioned performance security or to sign the contract agreement. In that case, my lord, they will forfeit. Now, if my lord takes up page 49.2, the above clause, within 21 days of receipt of the letter of acceptance, the successful bidder shall furnish the performance security in accordance with so-and-so and revise construction methodology. Then B is for joint venture, that is not applicable. Bottom my lord, and C shall sign, date and return the agreement to the employer along with the documents stated at A and B. So my lord, my mandatory obligation after accepting the letter of issue, acceptance is to deposit the rest of the figure by way of performance security and revise construction methodology. One, I was directed to file the revise. So at the time of bidding, I submitted my construction methodology. That was way back in the month of September based on the condition at that point of time. Subsequently, prior to executing the contract, I am bound to submit the revised construction methodology. Therefore, my lord, I filed a representation at page 57 after receipt of this, saying that I have gone to the site. This is the site condition. There are water and the water level is high. I cannot go. So please advise what to do. Because of the fact that I need to submit the revised methodology. And my representation is based on my page 24 plus 26.3. In the eventuality, I need to do something. I have to write to them in writing. So my lord, I wrote that. But why didn't you deposit the performance security? No, my lord, that would even otherwise would be forfeited, my lord, because I cannot do partly. Prior to signing the contract, I am bound to deposit the.
That is a different thing. That could have been considered anywhere. But here, what you are doing is, you say that kindly put it delay it to September. This is your representation. Kindly delay it to September, and thereupon I will do it. This is your case.
Yes,
and therefore that representation was not considered, and they had forfeited the amount. So therefore, my question is, if you had deposited the year, one of the grounds was not there. You have not deposited the performance security because you rightly so as per 50.2. And if you have anything, go to the civil court. Civil court may understand all these things. It's very difficult for me to understand.
Only thing is that
very difficult for you also.
Yes, fine. Sure. I was bound to give the two documents. Second document I could not execute. So
my therefore question was only one. Whether the contract was granted to you beyond the bid value. If it was beyond the bid validity period, then obviously you have a that my contract was this was the materials on which I have given. Subsequently, they have given. Now you have own put your bid validity period to a particular, and within that time, if the contract has been granted to you or the letter of acceptance have been, you are bound to do it because you have signed it. Within the term of the contract, we have signed it.
yes, madam. Because of that term,
we cannot. You see, there is no equity in contractual law. No equity.
I understand that because of 49.2, madam, since I was bound to give the two documents, I wrote to them to say that since I cannot now.
No, we. Yes. Let's discuss. Hard, Mr. H.K. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary appears on behalf of the respondent numbers 1 and 2. The petitioner herein is aggrieved by the annulment orders dated 14/7/2025, whereby the letter of acceptance which was issued in respect to 3 contractual works were annulled, and the bid security amount so deposited was forfeited. The brief facts which led to the filing of the instant petition are that the petitioner, in pursuance to a request for bids dated 12/2/2024, participated in respect to 5 contracts, which is that serial number 2, 3, 4, 5, and 6, isn't it?
Madam, page number 40, madam.
Which are the contracts?
1, 2, 3, 4, and 6.
1, 2, 3, 4, and 6. First, the said relevant contracts along with the other details as mentioned in the table of the request for bids dated 12th of February 2024 are reproduced here in under page 34 of the table.
Page number
1, 2, 3, 4, and 6. Isn't it?
Page number 40, 1, 2, 3, 4, and 6.
Why we are going to page number 4?
Based on page number 40, madam, these works.
Not 12 2.
No, madam, that was earlier.
Okay, in pursuant to the notice in the table dated 12/1/8/2020. 1, 2, 3, 4, and 6. 6 or 7?
6.
You sure?
Yes.
I think 7.
7 is the serial number, my lord. Clutcher bracket 07, my lord.
Huh?
The name of the work, my lord. Clutcher slash 07. Serial.
You sure?
Yes, ma'am. At page 56 is the letter of acceptance in respect of serial 07.
So no plan to. 1, 2, 3, 4, and 6. Isn't it? Same is put together. At the time of submission of the bid, the petitioner duly submitted the bid security as mentioned against each contractual works. The record further reveals that on 29th of March 2025, the petitioner was issued the letter of acceptance in respect to the aforementioned 5 contractual works. The petitioner duly accepted the letter of acceptance dated 29th of March 2025, thereby furnishing the performance security as well as the revised program as was necessary in respect to contractual works number 1 and 2.
1 and 2. Page
1 and 2. At serial number 1 and 2 of the request for bids dated 21/8/2024. However, in respect to the serial number works, contractual works at serial number 3, 4, and 6, the petitioner did not furnish the performance security, did neither furnish the performance security nor submitted the updated construction methodology and a revised program as was required. On the other hand, on 23/4/2025, the petitioner submitted that in respect to these 3 works, the period be extended to September 2025, inasmuch as the working season would start from then. The respondent authorities, instead of accepting the said representation, annulled the acceptance of the contract by issuing the communications dated 14/7/2000, respective communications dated 14/7/2025, which have been enclosed as Annexure Roman 16 to the petition. It is also mentioned in the said communications dated 14/7/2025 that not only the agreement letter of acceptance were annulled, but the bid security amount which the petitioner deposited had submitted was also forfeited. It is under such circumstances the petitioner had approached this court by filing the present petition. This court finds it very pertinent to take note of clause 50 of the instruction to the bidders, which relates to the performance security. Clause 50.1 and clause 50.2 being relevant are reproduced hereunder. From a perusal of the above two quoted clauses, it would be saying that within 21 days of the receipt of the letter of acceptance from the employer, it is the requirement for the successful bidder to submit the performance security further to that, it is mandated that if the performance security is not submitted, it shall be a sufficient ground for annulment of the award and forfeiture of the bid security. Taking into account the said terms of the contract, which the petitioner duly agreed to at the time of submission of its bids, the petitioner's bids, in respect to the three contracts in question, this court does not find any illegality in the impugned communications dated 14/7/2025, whereby the letter of acceptance were annulled, and the letter of acceptance in respect to the three contracts were annulled, and the bid security was forfeited. Accordingly, the instant petition stands has no merit for which the petition stands dismissed. However, in the facts of the case, this court is not inclined.
Because of the ongoing election, madam, all the staffs are against the election duties, madam. I will pay for madam for the 2 weeks time. Madam. I talked with the circle officer. He has stated that he will issue notice by this time. Notice has to be issued. Within 2 weeks, he will complete the process.
How much time?
Within 2 weeks, he will complete. She has stated like.
You are challenging what, Mr.
Not challenging, I am.
Not issuance of a
NIT, not
NIT,
NIT and. Got papers of that market.
Ms. Yuda, the learned additional senior government advocate, and Ms. Enbora, the PNRD, the standing counsel of the PNRD, submits. Some more time is required, taking into account that on account of the recent elections to the Legislative Assembly of the state, the entire district administration have not been able to carry out the necessary demarcation to establish this matter on 1st of June 2026 for an update. What is this?
Against an award, my lord, and the reports have come. May I pray, my lord, may take up this matter on a hearing.
There are two issues. The first I will give you. The second is whether the question of there should have been a backward. In the meantime, have you been reinstated?
Not,
Not you will file an application.
not with contempt, your lordship. I have filed under section 29. I have been instructed.
Before that,
Yes.
there's no state to the reinstatement of the book. There is no. So only the backward.
That-
So if you have not complied with the order of the labor court, why should we decide on the rejecting this? This is on the,
Now, the award is also on the challenge on another ground, my lord.
there's no other ground. Two grounds we have postulated to clearly delineate the market.
The ground that the reference, the subject matter of the reference, the issue was something and the decision which the lordship take up the issue was the justification of retrenching the worker. Now, the reasons for the justification is one thing and the legality of the retrenchment is another thing. Whether there were grounds for retrenching, that was not answered. The court said that since the retrenchment was not legal, so it is unjustified.
Then?
So, my lord, if the lordship takes up this matter on a hearing,
Why should we take up? You have not complied with that part of the order. Don't you think, Mr. Bottas? You can dismiss it.
may I take up this matter on a hearing?
Hearing every day is a hearing. Then we require further hearing in the matter. Was this motion taken up on a hearing day? You urged, I gave you the liberty to urge everything you have urged, and this court was not satisfied with the reinstatement.
I take up this matter, satisfy your lordship about the.
But anyway, it's a 2025 matter. We should finish it of taking into account the labor court matters, the very sad thing. That
So can it
Labor
be-
Industrial Disputes Act postulates the matter to be done at the urgent, and it is in our high court. These labor court matters have been delayed. This is not there, and thereby not only it is a problem to the management, but look, he would love the matter to be delayed. That's a different thing.
And it be on 19th of May, my lord. The hearing.
Hello? Taking into account that the records have been already received and the respondents are duly represented. You are filing affidavit, no?
No, your lordship, I will file in the game. Will file in the game.
This is the matter for final disposal on 26th May. On 26th May, liberty given to either of the parties to mention the matter for upgrading. In the meantime, the respondent, workmen, to be at liberty to file their reply on or before 19th of May, thereby giving an opportunity to the petitioner to file an affidavit in opposition by 19th of May, thereby granting a liberty to the petitioner to file reply thereagainst on or before the next.
Thank you very much.
The same was the past earlier shall continue in the next. Mr. Teacher Property, today you have so many matters before me.
Luckily,
You are very busy counsel, my lord,
fortunately,
and you are having all the matters against Mr. S.
no, my lord, that also is another privilege. My lord, this matter can be disposed of. In terms of paragraph 20 of page 103 of the affidavit filed by the election commission.
What is the matter about?
I, my lord, came before this honorable court with this issue in the earlier writ petition that your lordship took up today. Your lordship segregated the issue of non-holding of election of Silchar municipal code from 2020 onwards, despite there being specific mandatory provisions under the Constitution and Municipal Act. Now, I filed a separate writ petition in that.
This is the second one.
This is the second one, in which two affidavits have been filed, one by the Department of Urban and Housing Affairs, the other by the Election Commission, wherein they expressed their predicaments for non-holding of election due to the ensuing assembly election, which was held.
Page.
Your lordship will kindly take the affidavit of the Election Commission, my lord. Page 102. Paragraph 17 onwards, and their, my lord, undertaking is, their, my lord, contemplation is at page 20, is at paragraph 20.
that now that assembly election is over, they say that they will require 2-3 months for holding the election.
This matter. When did they file the affidavit?
They have
It's the matter on 22nd of July 2026. In the meantime, the respondent number 4 shall take appropriate steps as per their own stand in their affidavit in opposition. More particularly at paragraph number 17 to 21 of the affidavit.
highly.
Because disposing it becomes difficult.
I understand.
Please,
I am highly.
and your privilege to appear against
I'll
Mr.
give-
Emperor from
Yes,
the
yes, ma'am.
Yeah, your lordship, in this case, lordship, I have applied for the electricity connection on 16/7/2025. Lordship, the, thereafter, lordship, I have been deprived from the electricity connection, and also from the basic amenities, though it is the settled position of law is that, lordship, if a person is occupying is an illegal occupation and occupying a golf land illegally, there is a specific provision of law to dispossess him. Unless and until, lordship, they will take the recourse to dispossess from the land as an illegal possessor. Till that, lordship, they cannot deprive from the electricity connection, lordship.
Who
But
are you?
lordship,
Who are you?
lordship, I am the petitioner, and lordship also.
And you are in possession of whose land?
Lordship, I am the possession of a land, lordship, that is covered by doc number 764. Your lordship will find, lordship, at my
Where?
lordship, page number 13 is the lordship land details, schedule of land is there.
764 new,
Yes, sir.
192, the government land.
Yes, sir, government land.
Huh?
Yes, accordingly, lordship, we have been offered to apply for the Miadi Patta, lordship. Your lordship will find at page number 16 is the lordship application for acknowledgement for application of the lordship Miadi Patta. Page number
Why
16.
you are not giving the temporary connection? What does it say?
Forest as well as the, so forest is decided.
The forest land,
Forest.
occupying forest land, reserve forest.
As per our instruction, it falls under Hangrabari Reserve Forest. The coordinate.
Land reserve forest.
Only my,
Reserve forest.
only my submission is that
Sharma, what is wrong?
if an authority, there
No,
may be
Mr.
three authorities.
Sharma.
One authority has been permitted to collect the revenue, lordship. That is, I have, your lordship may kindly, page
Sir,
number 19, lordship.
You file an affidavit.
Your lordship may
That
kindly
is
come
the
to page
land
number
of
19.
464, 764 new falls in because here he says Hingrabai revenue village.
Yes, your lordship. I have
No,
applied from
as per our instruction, it is under Hangrabari Reserve Forest.
Reserve forest, not revenue village.
Not.
Mr. Ibot Thakur, the learned standing
Lordship,
down.
only one condition, Lordship.
Half of the forest
Lordship.
department submits.
Lordship, only page number 19, lordship.
No.
The page number 19 says, lordship, this is the revenue land, lordship.
Is in
Page number 19,
occupation
lordship.
of the Hangrabari Reserve
And the
Forest.
settled position of law is
Land.
that, lordship, if I am occupying a forest land, then also I cannot be deprived from the lordship electricity. This is the established position of settled position of law.
Where?
This is here, lordship, the full
Who
bench
was
judgment
that?
from the Kolkata High Court.
Huh?
This is the full bench judgment of the Kolkata High Court.
Go to the Calcutta High Court.
Lordship, the Kolkata High Court also relies.
Mr. Sharma, this court is not going to do it unless they file an affidavit to the thing. Let us find out. In a reserve forest, they cannot be forested unless it has been declared to be a reserve forest village.
Only for my submission, Lordship, your Lordship may kindly peruse the page number 19. Page number 19 is the Lordship GMC revenue they have collected from me. If an authority of the state has been permitted to collect the revenue from a landholder. Yes, your Lordship.
Matter has been pending for the last. It can further go forward. And thereupon to dismiss or allow, it can happen. So first, let us ascertain if it is a forest land. If it is a forest land, no question of electricity. Whether Calcutta High Court says it is only the Supreme Court or division bench can give you. From my side, you want.
Supreme Court has also says, Lordship,
Supreme
that
Court also,
if
Supreme Court also does not say that kindly give electricity connection in visa first.
Lordship, only page number 19, your Lordship may kindly come to page number 19, Lordship.
What is that?
Page number 19 is the Lordship revenue receipt.
Ah.
That is collected by the GMC.
So?
Lordship, if GMC has been allowed to collect the revenue from me, considering that that land is revenue land, then how another authority that claim that this
Show me
is
the assessment.
Lordship,
Show me the assessment register of this particular mayor. Show me the assessment.
assessment register, Lordship, I do not have, but
No, you should have it.
Lordship, but only the, in fact, Lordship, I have the document. I can rely, Lordship, that this is not the land.
Okay, where is
that
the
is
dark number? Where is the dark number mentioned in the payment receipt?
Lordship, in that page, your Lordship may kindly take a look. Dark number generally not particular. There is no options to mention for the dark number, Lordship, in the Lordship revenue receipt. There is no Lordship criteria to mention the dark number. If I am holding, then my holding number they have issued and collected the revenue, Lordship, from me.
So tomorrow GMT will be giving settlement.
Only my humble submission is that, Lordship, if an authority is allowed to collect the revenue from me, why the other authorities should be debarred to give me the basic amenities, Lordship? Since, in fact, Lordship, all the other residents, your Lordship may kindly find all the other residents, if they are, Lordship, occupying the forest land, how they have allowed to, how they have given the, Lordship, electricity connection to all other residents, Lordship. Your Lordship may kindly find page number 18. Page number 18, Lordship, this is the electricity connection. In fact, I can provide more than 200 electricity bill, those against whom they have collected the electricity bill from their residents residing there on Lordship. Only for temporary electricity connection.
Let me pass the order. Heard Mr. D. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. Where is the forest?
I'm for forest.
Okay, forest was made a party?
Yes, ma'am. I have 4, 5, and 6.
Where? Initially, you were not a party.
Yes, your Lordship. Subsequently,
Let Udas appears on behalf of the respondent number 1. Mr. B. Das appears for the respondent number 2, 3, 2 and 3. Ms. Udas appears for respondent number 1 and respondent number 7. It's Udas appears for respondent number 2, 3, 4.
4 I am.
2 and 3. Mr. Ibotago appears for respondent number 4, 5 and 6. Mr. D. Sharma, the learned counsel appearing on behalf of the petitioner, submits that in view of the settled principle of law, that electricity being an essential service, the respondent APDCL authorities cannot deprive the petitioner of the said essential service. In that regard, have referred to the judgment of the Supreme Court in the case of Inri, the Philip Dead versus so and so, reported in so and so file. Mr. Didas, the learned counsel who appears on behalf of the Electricity Department, APDCL, submits that the electricity connection have not been provided, taking into account a decision taken in a meeting with the district administration as well as the forest department not to grant electricity connection in respect to areas which falls in the reserve forest. Mr. Ipotagur, who appears on behalf of the forest department, submits that the petitioner is in occupation of the Hengrabari Reserve Forest, and as such, the petitioner has no right to remain in possession. He further submits that granting of an electricity connection to the petitioner could only be in violation to Section 2 of the Forest Conservation Act 1980. Mr. P. Sharma, countering the submissions so made by the learned counsel appearing on behalf of the PDCL as well as the Forest Department, submits that all the neighbors of the petitioner have been granted the electricity connection, and it is the petitioner who has been singled out by not granting the connection. Taking into account the above, it is the opinion of this court that the stand of the Forest Department be placed before this court on the next date. This court further would seek a report from an affidavit from the respondent APDCL as to whether then in the neighboring areas of the petitioner, whether any electricity connection has been granted, and if so, why the petitioner have been singled out. Taking into account that the electricity is an essential service, and the petition was filed in the year December 2025, and there is an urgency, list this matter on 20 May 2026. Affidavit be filed by the Forest Department as well as the additional affidavit be filed by the APDCL as directed herein above, as providing the instructions as stated herein above, as observed herein above, on or before 13th of May 2026. Next date you will get if there is no. Otherwise,
Highly blessed.
Non-payment of contractors bill matter, two lakh 53,000 rupees.
what?
53,242 matter.
Suppose. Okay, have you filed affidavit? Affidavit, instruction? Instruction to deal with the people to this. He has no instruction to go in play.
Okay.
Some time to find my reply, I wait for some time to find my reply. The affidavit in opposition file
Has been filed.
was filed. Has been submitted. Who has filed?
So, respondent formal.
Has been submitted. The respondent number 4 has filed an affidavit in opposition. The petitioner submits that the petitioner would like to file a reply. This matter again on, what is the matter about?
Regarding allotment of shops now, allotment of shops.
On 8th of June 2026. In the meantime, the reply will file.
Keep that back.
As per their reply, they are told that they have not installed. We have, this is fact. We could not install because the site has not been provided us. Installation of the furnitures, they are saying that as we have not installed the furniture, we have supplied, admitted. But as we have not installed the furnitures, that's why the payment is over.
10% not done.
Yes, yes.
90% you got.
Yes, 90% is good, but the fact is that, Your Lordship, we could not install the furnitures because the site has not been provided to us. This is the matter.
No site.
We have a number of representations, Your Lordship, on record. We have annexed annexure 1 minor.
Who made the contract?
Contract is at page 13, page 12, annexure 1. Relevant point is the point number 8 and point number 18.
Where the work order?
Several work orders. Your Lordship. I have not asked.
And balance 10% on satisfied installation or commissioning. Now, almirahs and all. Now, what do they say?
Page 23, my lord. Paragraph 4. Clause 18 of the rate of contract agreement, 90% payment is to be released on delivery of the items and balance.
Okay, you have not provided the site.
Not knowledge, my lord. Your Lordship may see the annexure 1, my lord. One of my affidavit, my lord. With respect to the subject cited above, it is to inform you that that has been given to the joint director to all the joint directors. That has been written.
It's okay. I'm not on that.
Yes, ma'am.
Have you provided the site?
But I have to take instruction.
So do one thing. You keep the money. With you. Don't allow it. But have an 18% interest on that till you provide the site.
But I have to take instruction whether
Better
they.
than the keeping it in the bank, na? Better than keeping it in the bank. In mutual funds also you won't get it too much. 18%.
Then that I have to take instruction whether they have given the site or not.
Each other, the learned counsel appearing on behalf of the petitioner submit that from an affidavit in opposition filed by the respondent, there is no denial to the fact that the petitioner had supplied the materials and the furniture. However, the commissioning of the installation cannot be carried out unless the site is being provided. The learned counsel appearing on behalf of the petitioner submits that the petitioner have written various representations for permitting the petitioner any area for installation for oblique commissioning of the furnitures, and the same have not been provided. Ms. So-and-so, who appears on behalf of the NHA, submits that she would obtain any instructions in that regard as to why the area had not been allocated for commissioning oblique installing the furnitures of the petitioner. So it is also observed that the petitioner had duly supplied the goods admittedly in the year 2024. The said aspect would be apparent from the communication enclosed in the annexure 1 to the affidavit in opposition. And 2 years thereupon has elapsed. The respondent shall also consider as the respondents may also consider This court shall consider on the next day as to whether interest can be imposed. Interest and or any compensatory cost can be imposed upon the respondents for not providing the space for installation, thereby depriving the petitioner of the 10% of dues in respect to the supply made. It's the matter again on 3rd of June 2006.
I have received the instruction, madam.
In this case for impleading me as the respondent number 8, my brother.
You want to be respondent number 8?
My-
You filed the application.
Yeah, I said that.
Somebody was asking for time or something. Oh, somebody files an objection. You wanted to file a.
I have no objection. Petitioner has been convinced that he is not going to be prejudiced. Petitioner is going to be, has been convinced that he is not going to be prejudiced if the implement is allowed.
Why somebody mentioned the matter in the morning?
Yes, me.
Then
Petitioner had the objection at that time.
in the morning,
Yes.
and by the time it is
Yes,
changed.
I have confused.
With an application filed for exceeding, seeking seeking the permission of this court to be impleaded as the respondent number 8 to the accompanying petition. The legal counsel appearing on behalf of the petitioner submits as a respondent number 9, or 8. No, 8 is the circular. 7 circular. Okay, as respondent number 8 to the accompanying petition. The learning counsel appearing on behalf of the petitioner submits that he has no objection. Taking into account the above, the instant application stands allowed, thereby impleading the applicant to the instant application as the respondent number 8 to the accompanying petition. The counsel for the petitioner is directed to file a fresh memo of parties within 7 days. And the registry as well as the shall make necessary changes in the course title and update the same in the CIS. You have the affidavit.
I'll file it. But the party need to file anything. Not filing.
Issue notice to the newly Mr. Each of property accept notice on behalf of the newly impleaded respondent number 8 and further submits that he has a copy of the petition. Taking into the council further submits that he will be filing the affidavit within 3 weeks. List this matter on 10th of June 2026. In the meantime, the affidavit will be filed on behalf of all the respondents. A final liberty is granted to all the respondents, including the newly impleaded respondent number 8, to file the affidavits on or before 8th of June 2026. No interim.
No, it's full.
Huh?
No interim.
So the matter pertains to non-payment of complex.
Instructions will be not, any trips, any
Instruction?
will.
No instruction.
No.
But it's only the verified pay. Okay. But whether there was a contract or not,
So not can be.
no. Then that verification will include that also. But all within 6 months. You don't follow PROCEED.
Not.
PhD names.
If this your worship will are entering appearance on behalf of the workman and I am entering appearance on behalf of the workman and
want to file it. If the issue raised by them is in fact not pleaded before the.
It's a case for against a Gauhati path by labor code. Reinstatement with full back wages and with cost. No stake. And reinstated. Not yet. You paid 17E. Then otherwise, how will you get a stake? But he's already engaged in some other case. Yes.
Worship that instruction. I will take.
Because the court has passed the order of full backwages. Means when it is a question of full backwages, means there is no, he's not in employment till 2025. Okay, you don't want to stay. It's the consequence. You want to file a reply. We do one thing, the court should come, no. Yes. Because the court come. Mr. S. Kotaku, the senior counsel assisted by so appears on behalf of the respondent number 3, na?
Four, respondent number 4.
Respondent number 4. It has been submitted to the respondent number 4 would like to file an affidavit in opposition. Taking into account that the award was passed by the learned labor court Kamrup in reference case number 7 of 2024 by an award dated 15/11/2025, thereby reinstating the respondent number 4 herein and to pay full back wages. And the matter requires an urgent disposal. Accordingly, it's the matter on 16th of June 2026 at 2 p.m. for final disposal. The records have also been received by the registry. Under such circumstances, in the meantime, liberty granted to the petitioner to file reply on or before 4th of June 2026, respondent number 4 to file affidavit in opposition by 4th of June 2026. Petitioner would be at liberty to file reply on or before 12th of June 2026. Next,
The MFL license holder expired manner. The license applications are submitted for renewal of the license manner, but the process is not been completed. So.
Who are you, Dilip?
Is the my lord, brother, the elder brother.
How will elder brother get?
Wife of the license.
Life will get.
Yes,
Not
wife,
elder brother.
wife is also applied, my lord. Wife is there with us, or
So why the wife has not come before the court?
wife should come with wife.
Let the wife come. No, sorry, we are going to dismiss this type of petitions.
So otherwise, that this is just two wives. The deceased, that he has two wives, Lordship. One is in favor of the petitioner, other is objected to give the.
I'm not on the question. Will the wife will get it?
No, no, wife.
Legal error.
Legal error.
Legal
Yes.
error.
You'll be the legal heir.
Legal.
Yes.
Elder brother would not come out in the ambit. First, it will be the class 1 heirs.
Yes.
Class
The
error.
class 1 heirs have to give up. Has the class 1 heirs given up?
Yes, she has authorized me to take.
No. You can be at best the power of attorney.
Yes.
Nothing to file the petition. You have no business to file.
My lord, your lordship, my lord, applications are pending before for renewal, my lord.
What?
Application submitted, my lord, by the wife also, my lord, page
No,
number
you want
20,
to transfer.
page number 27.
No, you want to transfer. You have put your name as Dilip Kumar Bhaumik, son.
Priya Bhumik, my lord, page number 27.
Huh? Where is the LR certificate of him?
Legal error certificate, my lord, page
Mr.
number.
Counsel, on the date of the licensing, the collector may with the previous sanction and renew the license for the remainder of the lease on the same terms in the way of the representative of deceased if he is satisfied survey is fit to hold it and on condition that any areas use of the deceased source is recovered. So this is permissible as per which act?
But the Assam excise.
So this is permissible under 301,
30.
but this has to be done by the, by the wife. Not by you.
Wife is applied, but the.
Mr. Focus,
yes,
this
that's
type of petition. No. We dismiss.
One thing, but I suggest, my lord, one my suggestion is there, my lord. Your lordship may directly the excise commissioner, my lord, to take a call on.
Why should I do it at the instance of you?
After hearing the, my lord, legal,
No.
yes,
No, not at your instance. Come up with the wife, we will do it. You are in favor of that wife,
yes,
na?
wife
Come
is
up.
with that.
Will you withdraw and let the wife come? Nothing. Come up with the legal certificate, legal and come, and that I have filed an application. Where is that application filed by the wife?
Wife has filed the application on my.
No.
Otherwise, we have informed the wife lordship that she is not entitled for this license. But the his brother-in-law is, yes, no.
He is not entitled. So we dismiss. Withdraw. Dismiss. 5 o'clock, what do you?
We'll come another table. I will take the instruction.
Mr. P. Prakash, the learned counsel appearing. This court put an inquiry upon the learned counsel appearing on behalf of the petitioner as to how the present petition is maintainable, taking into account that late Porimal Kumar Bhumik, who was the licensee, is survived by his plus one heirs. So the learned counsel appearing on behalf of the petitioner submits that he would obtain necessary instructions. List the matter on 4th of May 2026. On that day,
For a change, I am on the petitioner side, my lord. It is about
non-payment.
not payment.
You are a petitioner.
Right.
Against,
Water resource.
is the
Purpose completed in the year 2007 and 8. Now
Huh?
they are paying 2007 and 8 in the year. They have completed the work. Now they are paying the solo time.
no, but there was a requisition file now earlier.
These are also similar security person. They are saying that.
This is the second round of litigation. So therefore, I think you need to file a
Look, that's what it is.
because there was a direction for payment as per Kamsal. Isn't it? So we
Similar,
have-
Kamsal
we can't
is
just
similar
think of
to
like
not this
this.
part.
We have to direct you. You file your affidavit. Why the order has not been filed? Mr. El Toto, the learned counsel appearing on behalf of the revenue, who is to pay? The whatever?
Payment is to be made by water resource.
Okay, which, huh?
As their revenue department.
You have to pay. Mr. S. But the doctor appearing on behalf of the Revenue and Disaster Management Department seeks for 2 weeks' time to file the affidavit in deposition. It is the opinion of this court that taking into account the facts that the petitioner has approached this court for the second time, and there was a direction for making payment in terms with the order dated 21/4/2014, passed in WPC number 934 of 2014. The respondents in the Revenue and Disaster Management Department are directed to bring on record its stand by filing the affidavit on or before 1st of June 2026. No further adjournment shall be provided on the next date on this ground. This matter on 8th of June 2026. Okay.
Payment of contractor fee, page 14 is the liability statement of past.
Instruction,
No, it's in.
verify everything, including whether contract has been granted.
Item 52 similar matter. 52 is similar. 52. Page 13 is the liability statement.
52 is,
It also same. Page 13.
Madam, 52, let us take up one thing. This has nothing to do with the Jal Shakti, na? This I can't do. Let us wait for some time. Who has with Jal Shakti, ma'am? So let us have this matter again. Final opportunity granted to the Water Resource Department to bring on record its stand as to whether the petitioner hearing is entitled to the amount for which the incident with petition has been filed. This is the matter on 5th of June 2026. No, madam, one person.
Otherwise,
Let them find out.
let them verify and
Yes,
pay.
Prabhu. Can, there is no dispute on the amount.
Madam, the thing is like this. I've been dealing up with all this matter. I know where to do where. I'm asking there the water resource department, let them come up with this, that he's entitled, they will come up and say that this amount we have paid, this amount we have not paid, this amount we have to get it from Union Ministry of Jal Shakti. Then I have to direct there. So you want to understand, the direction has to be proper, then only we get the money. If I ask them to do it, okay, file it here, they would not.
Okay.
Mr. Hawk,
In this case, my don't interpret.
I am appearing on behalf of DS Nav, my lord. She has some personal difficulty.
who?
DS Nav irrigation.
I thought implement on I here.
You want to plead whom?
Where the two other contractors, my lord, were declared technical qualified.
There is an application filed for impleading the opposite party number 5 and 6 to the accompanying with petition, taking into account the reasons for which the taking into account that the petitioner have essayed the rejection of the technical bid of the petitioner, isn't it?
Yes.
And in terms with the judgment of the Supreme Court in the case of Afcons Construction Limited versus Nagpur Municipal, Nagpur Metro, so and so reported in 2016-15 HCC, so and so. The Supreme Court had categorically observed that the other technically competent tenderers are required to be made party. It is the opinion of this court that the instant application is required to be allowed. Accordingly, this court allows the new present application, thereby impleading the opposite party number 5 and 6 to the accompanying writ petition as the respondent number 5 and 6. Application. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the present order as well as the memo of parties so filed, shall make necessary correction in the cause title and update the CA in the CI. Shall file within 7 days. Mr. I stands disposed. Now, the main petition here issue notice upon the newly repeated respondent number 5 and 6. Steps be taken by way of registered post within 3 days. By tomorrow. By speed post.
I'll filing by tomorrow.
By speed post by tomorrow. By tomorrow. Post. This matter. By and again, issue notice upon the newly included respondent number 5 and 6. Returnable on 25th of May 2006. The steps be taken by the respondent number, by the petitioner upon the newly included respondent number 5 and 6 by speed post. By speed post by tomorrow. Post. In addition to that, the petitioner is granted the liberty to take steps upon the newly impleaded respondent number 5 and 6 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner shall effect the service by way of dusty on or before 18th of May 2025. No stay.
Really only the, since I did not make them part of the. My inspection is that the application which has been filed by the petitioner has been forwarded to the Shillong office of the customs department. So Lordship, and second thing is Lordship, the Sophos notice has been issued to the petitioner, but no reply has been filed till date.
Mr. So-and-so, the learned counsel who appears on behalf of the customs department submits that the application so filed by the petitioner seeking provisional release of the vehicle bearing registration number NL 07/AA-5366 have been forwarded to the custom authorities in the Shillong. And the same, any decision taken thereupon shall be duly made to the petitioner. In addition to that, the petitioner have been issued a so-called notice. However, the petitioner have not submitted any reply. List the matter again on 22nd of May 2026 for an update. You want to file reply to the so-called